Upra Mahapatra judgment. Upra Mahapatra judgment. Amarendra Kumar Mahapatra judgment. And we have dismissed the petitions. Okay. Yes. We have also directed implementation of the order of the tribunal within 3 months, if it is already not implemented. Yeah.
Supplementary list item 2, Writ Appeal 2428 of 2024.
What is this matter? G.
Judgment.
Sorry. I'm sorry. Pronouncement.
The writ appeal stands dismissed.
So let's.
It's a good judgment which my brother written. The thrust of the judgment is where you have not put the cutoff marks. You cannot arbitrarily subsequently say we have considered up to this point and therefore we will not do it. It's a good idea. In fact, I did not much see that any other judgment is there. Okay. That's the judgment which you have. You had argued well.
Supplementary list item 3, Writ Appeal 284 of 2025.
Yes.
I think mistake. That has referred this appeal, my lord.
Yes.
Your lordship, different occasions directed me to question whether these petitioners can be absorbed in any other post available vacancies. But the department remained silent. So as stated, last order your lordship directed, if the instruction will not come, then the matter will be hard on merit.
You could not seek further adjournment also.
I know, definitely.
No, we said that order reads that way.
I'm conscious.
Yes, start. Unless he wants adjournment. You want adjournment?
No.
But you were saying something.
I am the contesting respondent number
He
one.
wanted to take adjournment, he wanted to object that.
That is not my idea. Only to.
I'm conscious. My lord, 2 advertisements were made for engagement of Shiksha Sahayak so far as.
First, make a statement of the case. What is the case within 2 sentences?
Yes.
Then you can structure your argument.
My lord, challenging the order.
Yeah.
In, my lord, WPC number 50.
Perhaps his client is under a lot of pressure, so calling him very hard. Yes.
My lord.
What is that? What is the gist of the case?
My lord, I'm sorry, I'm coming up there. Challenging the order dated 21/8/2015 passed in WPC number 5077 and 2014. I am before lordship directed in the result the writ petition is allowed. The impugned order under Annexure 12 is hereby passed. The opposite party number 2 and 3 are directed to recast the merit list by excluding the vocational /Upashastri candidates, opposite party number 4, 6, and by issuing appropriate order of engagement in favor of the petitioners, either as or in any equivalent post without further delay.
Means what?
My sole contention is provided we shall recast the merit list. Your lordship directed to issue an order of engagement, provided they come within the merit. How can we give them appointment unless they come within the merit list with the notified vacancy?
How many vacancies were notified?
There by then, 137 probably.
Not probably. You have to be very certain.
My lord, I'm coming to the facts of the case.
Okay.
It has several rounds of litigations before your lordships. In 1 year, 2 advertisements were made. One is on 22/1/2011. Another is 8/12/2011. My lord, the dispute belongs to the advertisement dated 22/1/2011.
In the 22 January.
January 2011.
Correct.
This dispute comes.
How many vacancies?
390.
319.
390.
390 already.
My lord.
309 in respect of 309 in respect of Bhadrak district.
Bhadrak district.
Two education district, Bhadrak 1 and Bhadrak 2. 309, so far as +2 city is concerned.
309. Yes. And 8/12/2011?
That's not the subject.
That is not-
But you said,
Yes, I said, because both the advertisements, they are amalgamating at times, my lord. So I am segregating it, confining it to 22 January 2011's advertisement.
okay.
So this is advertisement
Dated
restricting to Bhadrak district only.
Bhadrak
Education.
Education District only. Bhadrak 1 and Bhadrak 2.
You are not J2.
Yeah, okay.
Bhadrak 1 education district and Bhadrak 2 education district.
Yes.
My lord.
But let me clarify one thing. Subject to lots of permission. खाली जो vacancy का था कोई दूसरा. There are total number of vacancies 1041.
For all the state, all the districts.
No, in respect of Bhadrak
1 and 2.
Bhadrak 1 and 2, total number of vacancies is 1041. Well, so far as +2 city arts is concerned,
Means?
well, +2 city, +2 examination
Qualification.
plus city examination. That is one of the eligibility criteria as per advertisement. Total 309 vacancies were earmarked for them. So far as +2 city science, 328.
Now, why 309 assumes significance?
Not 9 assumes significance because all these petitioners, all these appellants, they applied for the post of +2 arts because their qualification is +2 in vocational stream. So they come under the +2 arts stream.
My lord, I'm coming one up.
Okay.
I'm clarifying you.
Okay. Okay.
One guideline was issued on advertisement was issued. The minimum criteria was +2 examination. Candidate must have passed +2 examination in science, arts, commerce, or its equivalent examination with city.
+2 means UC.
+2 arts, science, commerce, or its equivalent, and city examination. City means the training certificate training examination.
That is elementary teachers training.
That is 80 years different.
Same footing.
Plus two,
Yes.
plus two.
Plus 2 or its equivalent.
Equivalent is also there. What is that equivalent?
Equivalent means different qualifications are there, like vocational, Sanskrit, it's all that.
Okay.
But with my learned friend's permission, subject to your lordship's acceptance, may I state the facts before your lordships?
No, not like that. It is, you are also petitioner.
Yes, we are dealing in the same group.
We'll come to you because we don't want to disturb you.
My lord, initial provisional list after the due date, my lord, an initial provisional merit list was published.
What is that initial? Why two adjectives? Initial, provisional.
Initial provisional, lordship may take it as provisional.
Provisional list. Okay, that's what.
Provisional merit list of different categories were published. Where?
When it was?
My lord,
Provisional merit list was published on which date?
provisional merit list was
Well, somebody can tell provisional date of publication of provisional select list. Merit list. That is important.
my lord.
In any case, corrected date,
I understand,
corrected events
because
have
it
to
is
be
not-
stated.
Not there in my.
Anyway.
My lord, except the vocational and Upashastri course qualified list was published. So the candidates having vocational and Upashastri course, they had approached your lordship. They had approached your lordship in WPC number 645 of 2011 and batch.
The
WPC
recruitment advertisement is dated 22/1/2010 for 1,000, totally for 1,000
for one.
1,041 vacancies. First off, we are concerned with only 309 vacancies of them looking to Bhadrak district 1, district 2,
Education district.
One and
one and Bhadrak education district 1 and 2. What is that 1 2?
There are education districts
have been divided.
within a district.
Okay.
my lord.
Prescribed qualification is +2 or equivalent and certificate
Certificate training course.
training course. First off, provisional merit list was prepared and published on those whose names did not figure in that had filed a WP number.
645/11.
Now, what the court did?
My lord, their lordship, they have sought seeking for a direction to an inclusion of their name in that.
Correct. What the court did?
Court that disposed of the matter on 18/3/2011, directing that the cases of the candidate completed close to vocational with city court, city training shall be considered by the collector, Jilla Parishad, and the provisional list of selected candidates already published accordingly be revised.
Was it coordinate bench or single judge?
Single judge.
In WP number so and so, that single judge wide order date 18/3/2011 directed inclusion of names of leftover candidates and to reframe the provisional list accordingly.
My lord, accordingly, the candidates with vocational and Upashastri qualifications, their names were included.
These candidates were those who had what qualification?
Vocational and
Vocational and
Upasas.
Upashastri.
Equivalent, my lord, equivalent.
Vocational or equivalent. Huh?
Equivalent qualification.
Up to equivalent.
That's correct. That is what you have said.
Accordingly, engagement.
Names of the leftover candidates, namely those who had equivalent qualifications to +2 plus CT,
Yes.
comma, were directed to be included in the provisional list. Okay.
Accordingly, merit list was drawn.
On which date?
Date, I have letter on that.
Accordingly, merit list was provisional merit list was
drawn
framed.
and the engagement order
Right.
were also issued.
These appointment orders.
No, engagement order.
Yes, sir.
Yes, sir.
In terms of this. No, it was only provisional list. It was not finalized. Final select list was made.
Yes,
Yes, there are.
that
This
revised
was
final
followed by-
list was made.
Final select list dated.
I
Leave that. Just you have to ask
Yes, yes.
this fill in the gaps.
My lord, the candidates didn't come in the revised merit list. My lord.
In the provisional select list that challenged before the learned single judge,
Yes.
how many candidates figured in that?
Only 3 to 4.
I think.
My lord.
How many?
No, it is,
How
but
many?
fact is correctly not placed, my lord. It will be difficult to rectify.
You are very
If your lordship-
respondent.
Yes, yes.
That will come.
My lord, in provisional list was not, my lord. Final list was questioned.
Final list was.
My lord, that
That
I
is
want.
my
I may
attention, you
be.
may be,
Anyway,
you may change.
No record. Both the list are record.
in the final list, how many candidates were there?
My lord, I'm just, my lord, in
It's a
final list,
arithmetical number. You can't
But that
argue on
is-
that.
that is, my lord, it is in huge because the voting list was there, final list, then voting list. Why they
We are
object-
asking in the final
No,
list.
my lord. Then it is there, my lord. I have included that. That is also available here.
So you
That is
talk
to be
too
calculated
much, I
because-
tell you, really.
Lord,
We are asking how many goats were there. You need not tell complete veterinary science of the goats at all. You want a number. How many were there in
no,
the
my lord.
final?
Then we have to
Otherwise,
calculate.
you get that.
Yeah, all right. Yes.
My lord. The candidates who didn't come in the merit list, my lord, approached your lords.
You said it, and we have said there is a direction to include. Accordingly, the final list to be reframed. Engagement orders have been issued.
Engagements were
Go
issued.
further.
And thereafter, my lord, those who have not got the engagement, they had approached your lordship.
It's those who did not get engagement means those who were not there in the list,
Yes.
or they were there in the list but they did not get the.
They were not there in
Not
the
in the
List.
in the revised list.
They
The
were
names were not
Oh,
there.
again.
Again, they had come.
Who were there?
My lord, in WPC number 7478 of 2011, disposed of all.
Next part. Written. Those who did not figure in the reframed final list
My lord.
and therefore had no engagement order had filed WP number so and so.
7478 of 2011, disposed of on 24/3/2011 with a direction to the district project coordinator to consider and dispose of the representation submitted by those petitioners within 3 weeks.
Came to be disposed of by learned single judge
My lord.
with a direction to consider their representation for inclusion.
My lord. Compliance to such order, my lord, the DPC issued conditional engagement orders
To them also.
to them also.
No.
Yes,
To the appellants, not to them. They were not engaged.
my lord. Thereafter, my lord.
No, not after. Yes, what happened you have to say correctly.
My lord.
Because we have to write the judgment. It end up in the Supreme Court. Then where we should go if you give all nebulous submissions?
No, my lord.
Correct submissions you should make.
An inquiry, accordingly, an inquiry was conducted by the DPC into the allegations raised by the petitioners. And in 7478 of 2011, during process of inquiry, the candidates having upasastri qualification enlisted in the revised merit list submitted individual undertakings that they had not passed any other +2 course examination other than vocational and upasastri examination. As such, they were issued conditional engagement orders on 30/4/2011.
There is one wrong thing happened with you. Their names appeared in the final list.
Yes.
Even then, they were not given engagement orders.
Well, because they were
You just have to change that.
upasastri, having upasastri candidate.
But it is not their case. So correct us, because we have correct
But their names did not appear in the final select
list
list.
also.
No, and in the revised final select list, the names of the respondents did not appear in that list. Names of the appellants were enlisted in that list. And they
So
were
another list was prepared.
No.
They did.
After the +2 vocational and upasastri courses were included, a revised merit list was published pursuant to the order passed by this Hon'Ble Court. In that revised final merit list, the names of the appellants are there. They were selected.
Who? State.
No.
No. We are the appellants. We lost before the single judge. And in the first merit, the state government is espousing importance. So their names did not appear in the final revised merit list. Our names appeared. We were elected and we were given engagement way back in the year 2011. And subsequently, where services were also regularized.
As
Primary school teachers after completion of 6 years of service. We have rendered more than 15 years of service.
30/4/2011, the engagement order was issued.
DPC examined the matter.
Not DPC.
Not DPC, he said DPC
Selection.
committee.
Selection committee.
The selection committee examined the matter and included names of these candidates in the final select list. And they have been issued engagement orders. They were issued engagement.
Well,
In 2011.
Specific
In my case, 34/2011.
in 2011. But there were other cases.
my lord,
Huh.
being aggrieved thereby, my lord, some persons who could not come within the revised merit list because of the engagement of the vocational and upasastri candidates approached the Honorable High Court in WPC number 182 of 2011.
The first batch was
Yes.
This batch is what?
This batch is, these people cannot get engagement because of their entry into that upasastri candidates, upasastri and vocational candidates. That is what the instruction is. Being aggrieved by some persons who could not come within the revised merit list because of the engagement of vocational and
So
upasastri.
among the upasastri and vocational,
Yes.
who were not included in the revised panel list,
They filed writ petition, another writ petition.
Since I am the conducting the council
No.
of the Commissioner, my lord,
Kindly, we'll hear you.
Let him go through it again. Then if you place it tomorrow,
No, not tomorrow. It started. It is like Jagannath Rath. No question of postponement. It has to run. It has to run its full course. Yes. All right. We'll repair again. Whatever you want to say, we'll repair it with the assistance of so many learned advocates. Yes.
My lord,
But therefore, always I requested from day one, on 12/5 I came here, I sat here. First day I say, where is your form list? Unless you have a form, we will not be able to argue properly. Unless you are Palkiwala, we are not. Yes.
It is
You. You supply a copy to them so that they will repair this.
Yeah,
I have prepared also. Prepared, I have explained.
Just repair this. Get Xerox copy. 2 copies you get and you supply them. Those the government's print. Yes. Get it Xerox there.
My lord, being brief, my lord,
Yeah.
some candidates they had approached in WPC number 18256 of 2011, which was disposed of on 15/7/2011.
17/3 2000, 15.
15/7/2011. Paragraph 8. The direction to the authorities to complete the inquiry and thereafter consider the representation of the petitioner in the light of the inquiry proceeded thereafter, and on its completion, candidate already in question were issued so-called notices for their disengagement. And after
When Shoka notice were issued, they also approached the High Court challenging that.
After the so-called notices, the said persons approached the Honorable High Court in WPC number 32024 2011. 32024 of 2011. In a batch of
Obtained the interim order.
an interim order was granted. At this stage, some of the candidates who could not come within the revised provisional merit list because of the engagement of vocational and compulsory candidates filed independent writ petitions challenging the engagement of the candidates having vocational and vocational qualification. Several such writ petitions having been filed, all were together and finally disposed of by a common order passed by the Honorable High Court on 5/5/2015 in WPC number 5077 of 2014 and batch, and the operative portion of the in a view.
Again, it directed consideration, nothing beyond that. We read that. You have produced
The
reproduction.
reply petitioner.
That's all there. Yes, next. We have seen that.
Order, the petitioners in WPC number 5077 of 2014 and all other petitioners in different writ petitions
Participated before the collector. Then what happened?
Then an order was passed by the collector.
Saying
The second order was under.
saying what? Collector passed the order. What he said? I will grant, I will not grant.
The vocational and the order which was the appointment order which was issued was valid.
Those who were already appointed.
Appointed
their engagement is
valid.
valid.
No.
Thereafter, the said order was also challenged before your lordships in WPC number 5077 of 2014 and 18706 of 2015 and WPC number 7 of 2016. The common judgment was passed, my lord. In the result, writ petition is allowed. The order annex 12 is hereby quashed.
So they directed excluding vocational training courses.
Yes,
Candidates.
excluding vocational training courses and issue the appropriate order of engagement in favor of the petitioner, either as a Shiksha or in any other equivalent post.
Recasting
the merit select list matter. That was the order. Challenging this, I am before your lordships.
One question.
Because-
What is the equivalent post?
Equivalent post is nothing.
Is there anything?
No.
But all along this order has been passed for or equivalent post.
There is no equivalent.
No Sikha side, only
Only
Sikha
Sikha side.
equivalent post.
No equivalent post
Because the
is there.
scheme is abolished.
Schematic post
Yes.
scheme is only for Shiksha.
Scheme is abolished.
That Shiksha has already been abolished.
By this time, how many years of service they have put in?
15 years. More than 15 years.
2011, my lord. On regular basis, they have become
2011, they were appointed, more than 15 years back.
Sikha sir having 3 years.
Junior teacher and 3 years thereafter, regular private school teacher. In 2011, they were engaged as Sikha Sahib. In 2014, they become junior teachers. In 2017, they become teachers. So they have rendered more than 15 years of service. And the learned Singilians.
Yes, my lord. How can we issue an engagement order, my lord, after recasting the merit list, my lord, on that comes within there?
But you have issued engagement orders pursuant to.
So far as no, it is under challenge for you, not saying.
No, you had issued engagement orders when?
It was of the year 2011. That was conditional.
Subject to outcome of.
But you will
After 15 years.
There was a condition, my lord. Collector found that engagement order was. Thereafter, my lord, this order was passed by the Lion single judge, which is under challenge before your lordships now.
No, we are asking you, if this writ petition is allowed,
Yes.
then those who have been working since last 14 years will be ousted.
Definitely. If they will,
There are only 5 to 7%.
my lord, if they will come within the merit list, my lord, definitely they will continue. If they will not come within that, they will not come. They will have to,
But last 14 years, they have been working.
my lord, condition.
Correct. Conditional.
Conditional.
It's true.
On the basis of their false undertaking, they were issued the conditional engagement order. Their undertaking at phase 77, your lordship will find.
Welcome. Wait.
Yes,
Mr.
you are
G,
but the respondent.
now, kindly do not disturb him. Already he is
Repeat, sir,
question
because-
from yeah.
So the issue is whether they have practiced fraud or not.
Confusion करो निमो पाकर जहाँ डाटा अच्छी accordingly I am submitting.
Yes. Now, Mr. G,
जहाँ जहाँ written notes अच्छी मुझे
Mr. G is angry now. We understand. But now, Mr. G, after a while, we have a question to you. After 14 years, perhaps they have married, they have begotten children, they have built a house, and where they should go. We are state now. You are not some business house.
No.
You are a state.
My lord, my only endeavor is that should get better education in the institution, schools. That is my only endeavor. Best candidates, best teachers should be our children. That is
But
our-
you have promoted them also.
Yes, Nicholas.
They were teachers. Why did you give promotion?
No. They have allegations made by the other parties.
No,
They have
question
got
is,
equivalent qualification.
no, sir, we'll come to that. So there is one judgment of the apex court which says experience itself is qualification.
Yes, definitely.
Bhavati Prasad judgment. So that also we have to keep in view. Our question is, see, we are not, we cannot go by Kelsonian pure theory of law. Kelson's pure theory of law. Can we go that way? We are an Asian country. Ours is an Asian country. We have traditions, poverty, limited resources. People structure their lives based on all this.
Well,
For 14 years, if they work and at the end of 14 years, you say, go home. Where they should go? You will jump into the river. That aspect is also there
yes.
because of Bhagavati Prasad.
That issue was raised before the Honorable Chief Justice. Honorable Court has said that get instructions whether they all can be observed or not.
That is the reason they have said.
And better was adjourned time and again.
But no instruction.
Department remained silent so that
Now all they have been working since last 14 years.
So far as the 14% they are continuing, but so far the private opposite parties are concerned. Now the only question is, their lists have come Select list or not. That is
That is what,
yes.
whether in the revised merit list, my lord, we shall have to recast the revised merit list in response to your lordship's order, which is under challenge before your lordships. Our predicament is the persons directed, they issue engagement order or cash or equivalent force. If they will not come within that, my lord, within the recasted merit list, my lord,
Many persons will go.
that is the problem. That is
Many persons will go or many persons should go. What is your version?
My lord, revised merit list is recasted again pursuant to the order of the
Many
Honorable
will go.
Judges. Many persons will go. Because there are number of Shastri candidates who are selected, more than 8,000.
carrying out your lordship's order.
And the Honorable Judges has only confined it to 3 persons who are respondents in that case.
I may be corrected to this statement, Mala. One thing. Vocational candidates, all will not be ousted. Those who are in suppression of passing earlier plus 2 arts or science, which is in a same course under the definition of section 2J and K.
Equal course.
They have been, after passing that, as they secured the 30 or 40%, they prosecuted immediately thereafter the vocational course and obtained that vocational certificate with 90-95% of mark. Because the basis of selection was the percentage of mark. Therefore, they got engagement. So let's say kind of visit. When the court come to a conclusion, those who have committed fraud and given false undertaking, they have to be go. That is the element it has been discussed. It is a finding,
You are a writ petitioner.
I am the writ petitioner. I have not placed my case, Malad. I am the writ petitioner.
Number
Yeah,
is
respond.
You are
I am
responding.
just clarifying. This is the crux, Malad.
No,
I have, Malad.
you are responding.
Yes.
Yes, I am
Not
responding
petitioner.
here.
not petitioners.
You are not appellant here.
No. Because I am the petitioner respondent.
You were writ petitioner.
Malad.
We will come back to you. Yes, Mr. J.
My lord.
How many have to be sent back? Just
My
give
lord,
us- suppose
if we
if
shall
we agree with your
my-
argument.
If we shall regularize this Upasastri or equivalent qualifications, apart from this, there are 32 other candidates who are fitting VIC.
They have not been given the engagement
They are
order.
watching the field.
They are also working.
No,
Not working.
They are watching.
They'll be included in the recast.
Not working.
If it's recast.
If in the event we make that,
They are watching.
They have not yet been engaged.
fact remains they have not been given engagement.
No, they have not been given a.
They because they did not figure in list.
Yes.
Yes.
All right. What is your first ground of attack?
These 3 persons so far as concerned, my lord, these petitioners in the, for your lordships in the single bench. My ground is their merit list should be recasted. Basing on the qualifications they have acquired either +2 or Upasastri, whatever you lord will direct. And the persons, those who are in the top of the list within vacancy, they will get the engagement order of engagement. And those who are not coming within that, they will be ousted.
Huh?
Contention. Those who will come within the notified vacancy, they will be engaged or regularized, whatever. And those who are not beyond that, my lord, they will not get. Let us, I have no choice.
Everything will be topsy-turvy.
Yes.
We are at the receiving end, my lord. Your lordship directed to include them, we have included them. Your lordship directed to consider them, we have considered. We are passing all this. We are implementing your lordship's order. Now, when this order came, my lord, it comes to creates hurdles, my lord. If we shall revise the merit list, and these people will not the revised merit list criteria within the notified vacancy.
How many of them have not been issued
Order of
engagement order?
engagement.
Here only 5.
5%.
Including the petitioner.
Only 5. Maybe because of that, it is directed, try to accommodate them elsewhere.
Yes. We have no objection.
Alert, there may be 5. If their serial comes below, much, many more candidates will be there above them. How can we accommodate all?
No, but only 5 are there. Only 5%
Only
are there.
5% are there before your lordship.
Correct. But those who did not come, they did not believe that. Therefore, they are not come to.
My lord, in the revised merit list, my lord, suppose these people's serial number comes at 32. 32. Above them, there are number of. No. That scheme has already been abolished.
Scheme is abolished.
Yes.
All right. Under scheme, all right. Other than a scheme, outside the scheme, there are no equivalent posts.
No.
Teachers' posts are not there.
Teachers' posts are there.
Yes, for them, those who suffer
Selection procedure.
because of this order, we are just thinking, we are just
My lord,
working
yes.
out patterns
Yes.
as to how we can do justice by in a paternalistic way. We are thinking. Those only 32. Five. You accommodate them. No, you are only thinking aloud. We don't think that we are directing you.
No.
Can't they be accommodated in other teachers first?
Yes, sir. Junior teachers committee.
No, they have to answer, not you. Because they have to pay the salary.
What about the scheme?
They have to continue today.
No.
They have to claim the benefit from 2000.
No, that we will
that
tell
will-
them.
that will
Don't
be
worry.
clear.
This, a dead horse is a dead horse.
My lord. That
Okay.
Yes.
Whatever little we can do, we can do. We minimize the injustice without burdening the exchequer,
Yes.
without upsetting the apple cart of these people.
My lord.
We have been working. Any complaint is there against?
No.
No.
No complaint. We have given promotion also.
Yes.
Regularized.
Regularized. If their performance was bad, not
They cannot
happy,
be regularized.
you would not regularize their company. Therefore, there is no complaint from any teacher,
No.
other colleagues or student,
No.
nothing like that.
Intervenor are there.
Huh?
When they come.
No, my lord. Single bench
Okay.
intervenor was there. Their intervention application was allowed, and they are also similarly putting with that 5. The 5 is the petition to represent. Around only 10 candidates are there. But here, if your lordship will impute judgment, will go through every facts, everything has been taken note of. And all these petitioners, they are before this court, before issuance of the engagement order. Engagement order was issued in April,
Let
but
us-
they have,
Yes, we will come to it.
and in pursuance to the order, merit inquiry was held.
No,
And
Mr. G. Yeah, Mr. G. Your first contention is the order could not have done that way.
Yes.
Is your
Exactly.
first contention.
Yes. And if we shall implement it, my lord, we cannot implement that order. We cannot issue engagement order, particularly when the merit list is recasted and these people are not.
Let us see the operative portion of the order. Judge.
Not quite to man. Para 22 is the result. The writ is allowed and the impugned order under annexure 12 is hereby quashed. Opposite party number 2 and 3 are directed to recast the merit list by excluding the vocational officers candidates of opposite party number 4, 5 and 6 and by issuing appropriate order of engagement in favor of the petitioners either as or in an equivalent post without further delay in any case not later than 4 months. If we shall implement your lordship's order, my lord, we shall recast it. No problem. We have no problem. Problem comes if this didn't come within the merit list.
What should be done to them? Without
how can we issue them engagement order, particularly when candidates above the serial are there? They will come again before your lordship.
The opposite party number 4, 5 and 6 are not the only vocational and upasastri candidates. There are numbers.
32 candidates are waiting.
correct,
And this judgment is only confined to opposite party numbers 5 and 6.
because others are not before the court.
Yes.
Others are not before the court.
If others are not before the court.
Suppose if recasting is to be done only with regard to these 3 candidates,
No.
No.
it cannot be.
It can.
From 17th paragraph, it
It
has
will
been
open up Pandora's box. Many cases will go to Mr. Dash, and Dash will bring the bunch of litigations here.
Yes.
That creates problem for the opponent. Lordship may decide the issue.
No problem arisen because of pendency of the matter for 9 years. Matter was pending for 9 years.
My lord,
If such matters to be decided within 1, 2 months, 3 months, all these questions would not have
different
taken.
times, different rate applications were filed challenging.
When very ad hoc approach, the one case will be decided like this, another case will be decided like this. There is no comprehensive approach to the entire recruitment process.
Problem. Lordship may decide the issue.
You have put he has washed his hands now. Anyway, but I don't think that matter will rest here. It appears to travel to the north of the country.
I don't think your worship can close it here.
No, we will
I don't
close.
think that your worship can go to in a High Court. If your worship will decide it, those who have come to the court and confined to the part, even if you recasted, that the person those who have continued for last 15 years, they
There
have
are
got
only
almost
5%.
will
Only 5% and they are only 3.
Not yet engaged.
Not yet engaged.
So you 5 are already engaged, 3, 4, 5 and 6 are not engaged.
Not engaged.
4, 5, 6 engaged.
No,
4, 5 engaged.
just reverse.
4, 5 and 6
Just
are not
reverse.
engaged.
That is what.
We are
They
not
were-
standing on their way if they are engaged either as Shiksha scheme is abolished. Now junior teacher schematic, that post is available. They can be adjusted against those posts.
4, 5, 6 were the party to the petition. And but who's the petitioner in before the single judge, they have approached even before issuance of the engagement order. And in the first, that everything is available in the case record. But there the honorable single judge directed for an inquiry. The grievance in not self it will find. But if they will be
concerned, if any judgment is passed by this honorable court, my
Whenever
lord,
will come.
approving the judgment of the honorable single judge, then my lord, it will upset the entire state, because other candidates in other districts, they will also be affected. A cavity situation will be, there, my lord, rightly, if those three persons are accommodated in any other post under any other scheme, then matter will be resolved.
No, the others who have not yet come to court, now they cannot come on the basis of this judgment.
Yes, absolutely correct. And some have filed intervention petition.
What we should do?
No one is come to even press that. So intervention petition.
Yes. No, is there? Madam is telling it.
Watching.
He should get somebody because by virtue of some orders he has been given engagement. That should not be confirmed, my lord. This is my view. I had prepared also this matter. Your lordship may decide on merits. That will.
No, it is very the option for us then to decide. We have no option at all. You have option. But we have no option because you have argued we have to decide the matter.
Because some persons, those are entitled to from 2011, they will be given appointment in 2027. And those are not entitled, they will enjoy.
Continue as from 2011.
Then that is why you
That's all right. That is not because within 3 years they have qualification. But the definition, secondary course is years they acquired +2. Thereafter vocational within 3 years. How could it be? In suppression of Malad.
You should permit us also.
Malad.
We are asking you. You are in which writ appeal? You are in only respondent.
Yes.
You
Read petitioner.
You want to support the government?
No.
No.
Malad.
You oppose the government, Mr. G and Behura, or you sail with them?
No, Malad. I have something.
Understood.
This. Because everything has been taken note of and 2 writs petition. In first
Why so many writ petitions actually?
Yes, Malad.
How many writ petitions?
Now, if you are affected, those are parties.
Those who are affected, they have
filed writ appeal against the very same judgment.
Malad,
They are filed.
not leave, they were parties before the honorable single judge.
With leave of the court.
No, but they were parties before the honorable single judge.
They got implemented.
No.
They were in
They
the
were
read
parties.
petition.
They were
They were parties
parties.
in the read.
No, how many writ petitions, writ appeals are here now?
It appeals 4 to 5.
Why 4 to 5? Who are the appellants?
Appellants.
Other
In my
than
case,
sir.
all appellants are opposite party.
4,
Yes.
5 appeals. Other than state. So
Who are these 5 people who have preferred the appeal?
But these 5 persons who lost before the honorable single judge, because the select list was passed,
no.
they were engaged in 2011.
This is question.
So they are affected.
Party before the single judge and lost the case because of this.
Now, they were not issued any appointment orders?
No, they are continuing.
We are regularized.
15 years.
In 2011, our services have already been regularized.
They were initially
We have
appointed.
rendered more than 15 years of service.
But
Questioning of annexure 12
That is
is affecting these 5?
Yes.
That
Select list has been order has been passed. A collector's order.
Collector's order.
Collector's order has been
That
passed.
is Annex 12.
Finding.
Yes.
These persons have committed fraud. They have suppressed.
No, he has not given any findings that they have committed fraud.
They have not challenged that.
The order of the collector is in our favor.
But the
What you
collector is, even if they have suppressed the fact and got the order by acquiring qualification by fraud, also giving false undertaking. But since they have continued for 4 years, they may not be thrown out from their fraud and bread and
The
butter.
collector's order is in our favor.
That is why it was challenged, my lord.
No, that is not correct.
And my lord,
It is
the
not
court came to
factually
a
correct.
conclusion once they have acquired the qualification by committing fraud, and also further, when authority says you give the
Where is the
who have not passed +2 hours
Well,
of
the-
earlier course,
No,
they
no,
gave no.
no.
Thereafter, the conditional engagement order was issued.
Where is the fraud finding by the learned single judge?
Yes, my lord.
No, the
Your lordship,
findings of the
your
learned
lordship,
single
kindly,
judge,
kindly.
they say in one
17
line.
paragraph.
The
Paragraph
findings
17.
of the learned single
Let us.
Yes.
Where is that? What is that fraud?
My lord, my lord.
Para 17.
My lord. 17 and above also every discussion is there. My lord, I'm just. It's. It's.
Lordship. Para 14 is most important. Because in para 14, it has been said that they have not committed any fraud. They might have appeared in +2 examination and subsequently in +2 vocational examination. Your Lordship, may kindly see para 14. It has been argued at length that the private opposite parties could manage to
From 10 it will clear, my lord.
अरे ठीक है वो थ्रू सर
That is part, that only part.
Go.
My lord, therefore,
Sir,
it's
in any case, we will be going through the paragraph. Whether you say or not.
Paragraph 14.
my lord, the other
We
paragraph.
have to go
It has
because
been argued
in any
at
case.
length. It has been argued at length that the private opposite parties managed to obtain the vocational certificates by suppressing the fact of their passing +2 examination and by obtaining duplicate transfer certificates from the institutions where they had appeared for the high school certificate examination. This court need not enter into this controversy or render any factual finding thereon, as it has already been held that irrespective of the manner in which the private opposite parties managed to obtain the vocational/supersastry certificates, the same can have no legal sanctity. Because my lord, the state government issued a circular in 2011 and all these persons have passed +2 vocational examination in 2006, much prior to that. Much prior to 2011. The restriction came in the year 2011. In 2012, the state government issued as well as the council issued a circular that those who have passed +2 arts, science or commerce, they cannot appear in +2 vocational. Because of that restriction, this controversy arose.
Anything new to be stated by anybody? Anything new to be stated? You have said fraud. We read all the paragraphs now. Do you want to say anything on that?
Only the provisions of the law, my lord. Yes, sir. And the provisions of the Act, Secondary Act, and the regulation.
Say,
My lord.
Your Lordship, may kindly see Bhagavati Prasad judgment.
yes.
My lord, this Bhagavati Prasad judgment.
Where experience is to be.
And other judgments are there. Your Lordship, may kindly come to paragraph 6. Paragraph 6.
Yes, you know, it need not be written.
And another judgment that Pradeep Dingle. My lord, and your Lordship may kindly, Your Lordship may kindly come to paragraph 45. Paragraph 45 of that judgment, long continuance, even if made illegally, that cannot be disturbed. Paragraph 45. And here,
it was, they said that by the time we disagree with all the perspective, it is the influence of the
and my lord, another judgment, because my learned friend is harping on that undertaking. That undertaking was taken under coercion, and where undertaking has been furnished between my lord unequal bargaining power, that undertaking cannot be accepted. My lord, I have brought a judgment. The Honorable Apex Court.
That inland water.
Inland water. My lord, may kindly see part 92.
Okay.
Yes. Then my lord, the another judgment of the Honorable Apex Court. Here, my lord, he has only implicated 3 persons as parties, 3 to 4, not all, although all were engaged. And here, And because of that reason, the petition was dismissed. Paragraph 16, last paragraph.
Yes, understood. Next.
That is the fault of the university, and after such long lapse of time, now you cannot say that the qualification which is acquired by him by the subsequent Berhampur or Sambalpur University can be treated as bad. That judgment was upheld by the division bench of this honorable
Was he
court.
given employment on that basis?
Yes.
So they wanted the opponent wanted him to be removed on
Yes.
that ground.
Yes. Yes. Yes.
Milord,
Yes.
Yes.
My lord, your
Yes,
lordship,
yes.
kindly see.
Yes, we'll see that.
Yes.
You have said we'll definitely go through.
Yes, and then the division bench judgment upholding the single bench.
You.
Good. Yes, sir. Division bench. Sit us. Division bench also affirmed it, and the matter was carried to the honorable apex court, and it was dismissed. Paragraph 12 and 13. 13 of the single bench judgment and 15. सारे कौन को running 12
Yes.
That is one.
my lord. My lord, in this case, my lord, we are not challenging their qualification. The question is about whether they were eligible for this post or not, or whether the eligibility is bad in law. My lord, the advertisement itself states +2 or vocational or upashastri candidates, my lord. And the circular that came late in 2011 saying that one person may not prosecute both +2 and upashastri and vocational education. That was a clarification of the earlier statute, my lord. That was not a new imposition, my lord. It was, yes, my lord, that was not a new restriction. It was only a clarification
Any other person wants to say anything?
my lord, in an earlier occasion, your lordship.
Go. Next. Not a journal.
It is short book. By morning fast. Tomorrow by morning.
Not tomorrow, today itself. Because we have to start judgment. We should not forget what all we have argued. You have seen us. We don't take much time for writing. You can give it today only. You leave it before 5, before 6. You leave it. Yes.
Item
Next.
4, item 4, WPC 7689 of 2026.
Yeah.
Item 4,
None appears for the appellate. Call after 3 weeks. Yes.
item 5, W820 of 2024.
May I please, your lordship, item 4.
Yes. For your appearing. Where are you? When matter is called.
My senior is going to drink water, my lord.
All right. You will start now.
The parcel work करता.
Kindly
You
pass.
start. You start. Just.
I don't have any.
I don't have. All right. Pass over. Yes.
sir.
Huh. Yes.
I beg apology.
No, just all right.
Here in this case,
Huh.
this is the matter related to reacting law. The petitioner is the loanee.
What kind of loan?
He has availed
Housing loan.
housing loan and commercial loan.
Both.
Both. Your lordship kind of a annexure
Housing loan is of which year?
2019. But as even in paragraph 17, they have given a statement.
State wise.
Paragraph
Then,
17, annexure 1.
Housing loan is of 2019.
My lord.
Then
Housing loan
commercial.
is 18 lakhs
Commercial.
and commercial 46 lakhs. Total 64 lakhs he has availed.
Commercial was taken when?
That is in the before Corona, in the 2019 in the midterm.
Earlier housing loan was?
19. Both loan were taken in the 19.
Housing loan is 18 lakh.
18 lakh.
My lord, 18 lakhs.
And commercial loan is 46 lakhs.
He was running a shop.
All right. How much you have paid, repaid in this?
Well, he has paid 22 lakhs. Well, after Corona, his business was down and he could not able to make some payment. Thereafter, you also see there is the dated on 9/12/2023 at page 17, running page 17 of the Annexure 1. The bank authorities has given Annexure 2. Annexure 2, the housing loan, that is principal amount due was 9,170 and the total amount due 57,000 into interest calculated up to 9,3.
No happened.
Four loans and insurance they have covered, they have clumped up together, and total loan was outstanding. That outstanding was 2,05,000. I could have able to make payment. Instead of doing that, they made record all the loans. They made merger of loans without my consent. They recalled all the loans and Annexure 18, you know, the next page.
Petition notice is issued.
No, not.
None.
Thereafter, they issued notice number 13.2 and 13.2, and with that notice are not sought. Again, they came and against that 13.2 made my representation to disclose. They have neither disclosed any representation. Thereafter, immediately they issued position notice.
Yeah.
Both the notice where I have challenged before the DRT, Annexure 2 and Annexure 2.
You are before the DRT now. SA
Yes.
62.
This is pending, still pending. Appeared, filed a counter. The matter is under subject, is not finalized. And again, they have filed another Annexure 3. They have filed claiming the certificate of claim that their case was Annexure 3. Bank has filed another. They have filed on section 19 of the Act claiming the certificate to declare certificate of claim, so that they will take up possession.
14 is over.
14 is over now.
Yes. Now 14, since both the proceedings are pending, they suppressing those facts. They will
Challenge that. You challenge that.
I have challenged.
14 you have challenged.
14. Well, in this case, they went to collector and against 14. Collector has passed within 7 days. We will take up possession to that is Annexure 6. I have been agreed by that order because that becomes premature one since we got pendency of those applications. Because may I read?
No, there whether any interim order is there in the
No.
Then where is the question of interdiction?
Because section
Because nothing is covered by the judge.
Section 14 itself indicates. I'm reading that. Section 14. 14, subclause 8.
What is the amount due now? What is the outstanding amount?
They have made 82 lakhs.
They have made it 82 lakhs plus.
82, 76, 82
Yes,
lakh
ma'am.
76,647.
Yes.
About 83 lakh now.
Yes.
Now how much you will pay now?
If you're direct, I can pay 20%.
30% you pay.
30%.
Then we'll look into.
You're from a direct, you're may give some installments.
Krishna is calling in question of recovery at the hands of the OPs under the provisions of Surface Act 2002, having suffered Section 14 order at the hands of collector. First option. The net counsel for the petitioner vehemently argues that his essay number 62 of 2024 is pending before the DRT, and OA number 737 of 2025 of the bank is also pending. First one. Semicolon. During the pendency of these two cases, the bank could not have taken the sledgehammer of Section 14 proceeding, especially when petitioner has already remitted about 22 lakh rupees periodically, and that he is now ready and willing to make substantial payment in payment towards repayment of the loan. Loans in question. First one. it tells us that if the impugned action is not interdicted, comma, he will lose possession of the subject property, and therefore court should come to his protection, at least by way of an interim measure. First off, he tells us that that is how his application in IA number so and so, the way affidavit is structured. First, next one, having heard letter counsel for the petitioner, peruse the petition papers, we are of the considered view that the matter merits a deeper examination, and till that is undertaken, some interim protection, subject to some reasonable condition, has to be afforded. First, in the above circumstances, issue emergent notice. Who appears the bank?
Lord, there is notice has to go.
Issue emergent notice to the OPs, returnable within 2 weeks. First off, the parties are directed to maintain status quo as to the possession of the security property till the next date of hearing. It is poured on.
No, this is 1 to 4.
Subject to petitioner paying 30% of the outstanding amount in 3 equalized fortnightly, weekly installments. Every week you have to pay 10%, 10%, 10%.
At least you have to pay 4.
Right? 3 equalized weekly installments. Okay. Next.
Pardon me, Lord. 1 to 4 state. 5 back. Only 5 has to be
State notice of notice. Issue emergent notice to file. Right?
The annexure 6, that order is to be stayed.
That order will not stay. We say status quo as to the possession of the property. What will happen, we do not know.
Fine, oblige. Order copy.
Project copy. Yes.
Item 5, Rate Appeal 208 of 2024.
None appears for the appellant. State is the appellant.
State appeal.
What is on merit? 2 weeks at the request of AGA Mr. Mohanty. Next.
Item 6.
In item 6, I have filed one IA for correction of the order dated 27/2/2000.
Order to be corrected. Any mistake is there?
In page numbers, first page of the order, my lord, first para, first line, the WPC has been written instead of WA.
The first line, WA instead of WPC to be entered. First.
In the second case also the same.
Then application is going on. The structure and application supported by seek verification of the order. First off, instead of mentioning writ appeal, the first line of the subject order where the petition was disposed of mentions WPC, you'll see, and therefore the rectification we agree. Okay, next.
Item 7, Rate of
Both the IA,
of 2026.
there are 2 writ appeals, my lord.
Both the matters they should be.
Sub-item, sir.
Yes, first.
Milord, I am here virtually.
Litigation team. The application will serve yesterday. You can find it again.
You want time?
So for some time so that I can file objection.
Time. Milord, I am appearing here virtually. There is some urgency, therefore we mentioned it yesterday. The respondents are pursuing with the contempt and it has been posted to tomorrow, notwithstanding the
The contempt is concerned, I undertake that we will not proceed
Yes.
tomorrow.
Let them not proceed.
order, because the officers are being, just a minute.
Any date, so that matter can be.
Let you also pass a judicial order during the pendency.
Finally disposed.
Heard. Learned.
The one advocate general is ready. If you also fix up next week also, we are ready.
So next week, actually, I am having severe throat infection for last 15 days.
After 2 weeks.
This is a kind of.
We are not precipitating the.
No, your lordship may pass that order because the officers are being hauled up in the court.
Just hold on. The limitation petition which has been filed, on the assumption the period of appeal, filing of appeal 90 days, it is actually 30 days. If the limitation is more than 300 days. And the problem is they themselves have filed an application there.
Limitation is 300 or delay is 300?
Delay in filing the appeal is more than 300. That is one. The second is whether the appeal at all can be maintainable. That is also can argue easily. While the contempt application was filed, an affidavit was filed that they're complying with the order and they undertook to comply with the order. Now they also accepted in the limitation petition, since they filed an affidavit accepting that to implement the order, but that was not accepted. Therefore, we are trying. So those are all grounds so you can take. You also can take up this matter finally.
Heard. Learned AG, Acharya, learned senior advocates.
Worst matters.
First off, we are told that the sword of contempt proceeding is hanging on the officials of the state who have to be the appellate sitting, and therefore some interim protection needs to be done. First off, learned senior advocates appearing for the other side very fairly submit that the contempt proceeding shall not be precipitated till the next date of first. This is really appreciable. First, in view of the urgency pleaded, put this matter on 6th of April. 6th of
As you lordship.
How many matters are posted? 6.
So there will be 4 matters.
4 matters. Yes, add this on.
6th of April.
All right, Mr. Acharya, will it be all right for you?
My lord, it will be all right. Any day, my lord.
Next.
Item 8, read Article 40 of 2026.
Both 6, 7 and 8.
All along with each other. Yes, next.
Item 10, read Appeal 1931 of 2024.
Yes.
Only tomorrow.
All right. Next week you have. I'm not sitting tomorrow.
Because I have an objection. Why I am objecting? I filed a contempt petition, taking the plea that rate appeal is pending. My contempt was dropped since 2024.
Okay.
And every time.
Next week we'll do.
Yes, ma'am. That's I do not.
How many matters are posted? Monday, Tuesday, Wednesday, Thursday.
So it is around more than 70.
No, Thursday.
It is on 17.
17 matters. Wednesday.
So it is also 14.
Sir, we'll have it week after next because the next week is fully loaded. It may not reach at all.
Yes, ma'am. 14 matters on Wednesday.
On 14.
He is saying that 14 matters on Wednesday. On that date.
14.
No. On Wednesday, if it was.
All right, put it on Wednesday.
No, not 14. I am saying on Wednesday.
Wednesday is what? That's what.
18.
18. Okay.
Yes.
Yeah.
Item 10, read Appeal 740 of 2025.
May I please, Your Honor?
Yes.
This application has been filed by the petitioner, who was the opposite party number 4 in the rate application, challenging the order.
Election matter.
Yes.
Rejection of your nomination paper.
No, my lord, not that. Actually, I have filed nomination, election process started, I filed nomination, then election was fixed on 29/3/2025. After the election process started, writ application was filed by the president of Kotak Bar Association to to delete my name from the rolls. The Bar Council of Orissa has stated that they have filed the counter. Yes, her candidature is there, her name cannot be removed. Election officer also said no. Then accordingly, money was accepted. She filed the nomination. Then just 14 hours before the election on 28th March 2025, the order has been passed by the Honorable Single Judge that
is passed on
28.
2025.
Yes, madam. May I take your lordship? That is annexure.
No, 7.
Annexure.
Last year.
Yes. And from that day, then I filed this. Then writ appeal was filed. Writ appeal was dismissed on a wrong conception. Then review was filed. Review was allowed. Then today, before your lordships, only this matter is placed. And now the ensuing election is 26. And now
are you a candidate in the ensuing election?
Ensuing election, I could not. On 9th, when I went to file my papers, they again my 26, 27 electoral rolls, my name was there. And when I went for filing nomination on the last date 9th, they removed my name, that is erasing. I have filed this miscase. So thus 11.
Whether writ petition is maintainable. It's a bar association.
Yes,
society.
that is not maintainable. The order has been passed. And so many grounds, 5-6 grounds are there. It is not at all maintainable. And on that case, basing on that, President has filed the case. I have taken my first ground that as per the bylaws, only Secretary and Joint Secretary are entitled to file case. But the President has filed. Then thereafter, another rule is there that minimum, that special resolution basing on which they have passed some orders against this present appellant. Yes. That is that special meeting.
All right, now what is the urgency?
Urgency that to day before yesterday I have filed the petition that she may be at least now could not take part. At least she may be allowed to vote. They have removed my name. But it says yes.
You have said. You want to process what you have said, or you will go on arguing. Now, suppose if sealed cover voting is done, what will be the prejudice you will put to?
First of all, my lord,
you permit her to vote by sealed cover.
I am appearing for in the writ petition, that is 7342/2000.
Now, how writ petition is maintainable? Yes. It's a society. 84 Supreme Court says, yes, ordinarily against the private society's actions, no writ petition lies. Even if public official functions as a nominee, as a persona designator, that's the judgment of Justice B.P. Jivan Reddy.
For that, I pray, my lord,
88 Supreme Court.
Yes, for that, my lord, I pray, as I am appearing for in the writ petition, I am the petitioner in that case. I have engaged Mr. Gopal Agarwal, senior advocate, my lord.
You permit her to vote in the sealed cover. My lord,
she has filed.
To be put a ballot. It's by ballot paper.
It's a ballot
paper. Yes, that
my lord, she has filed the IA number 1042/2020, my lord, stating that her
how writ petition is maintainable.
My lord, that was for the previous election, my lord. For the year 2025 and 26. Now, thereafter, the election has commenced, my lord, fresh elected body.
All right, now you
how fresh call of action.
Do you remember? We had one case, Ashby versus White, by English court, where right to vote was cut short, but the person for whom he voted was elected. Still, the House of Lords granted damages. In fact, in cross-examination, he admitted, the plaintiff admitted in the cross-examination that the person to whom I wanted to vote has won the election. Even then, it was a case of injuria sine damno. Therefore, what we will do is let Madam vote.
Yes, for
And
that,
you keep it in sealed cover. If the result does not alter, you need not open the cover also. If there is winning or losing by one vote, Vajpayee government,
yes,
because of Saifuddin Soz, one decisive vote happen also. In that event, you will open.
for that moment, my lords, as
how you will be aggrieved by this order?
Because of the I am for the previous president, my lords, former president, my lords.
How you will be aggrieved by this order?
Because they have not implemented the present president or the secretary or the present election officer. So without, they will be highly prejudiced, my lords. Second thing, my lords,
what is the how you are going to be aggrieved by our order?
Yes, because of the fact that disciplinary authority
in the sealed cover.
Disciplinary authority has already cancelled her membership.
That we have to examine, na?
So on that basis, I will file an objection. Short date may kindly fixed because the phrase 28, Your Lordship. 28
for the mistakes committed by them is senior advocate president.
Let us. When the voting, what about 28 is this matter on that right. 23rd will call.
I'll file the objection to the IM.
In the meanwhile, you want to, whatever you want to do, give copy to Madam.
Final hearing.
File it in this one. Let months. We don't know what it will be. Yes.
Item 11, WBC 4007 of 2026.
This is that union matter, the largest member, largest member.
We are appearing today.
Yes.
I require 4 weeks time for filing counter. And there is also in his writ petition he has mentioned in para 23 another matter touching the same issues.
We'll call that matter also.
Yes.
Is it before this court only or before other court?
I don't know where that is.
Object to my learned senior making submission, but she will kindly appreciate this. This is the trade union having today I have filed on every document on affidavit bearing my membership. The MCL has given a chart of membership of all the trade unions there. I am established highest membership. Today they are trying to kill me, the union, because the membership is going to take place in March.
March when?
31st of March. And in the process, 1 second.
Let me
appearing for the petition.
I don't object the copy. Please allow me to submit one.
Not even possible.
That's right. I appreciate that. I am not objecting to that effect. What I am trying.
Matters which the copy has not yet been solved properly, he should not have placed.
Kindly see, my lord, why I am placing. Your lordship issued notice. It's not today, yesterday's copy.
Yes.
Kindly see. Kindly see, my lord.
Copy solved.
1 second, lord. Kindly see, your lordship. On 12th of February, 26 notice was issued. It was sub new. You did not appear. You have no respect to the honorable court's order. You did not appear. On last date, I argued the matter. Your lordship wanted that the management should be heard. I directed me to serve a copy. I served a copy on Mr. Sharma. So it's not a case that for the first time they are coming to know about this. But I appreciate their stand. But my urgency is, my lord, kindly consider this. My union is going to be killed because every day, because of my lack of my negotiation power, members are leaving me. That's the problem. The union is killed, my lord, by the management at the instance of my trade union.
We are the largest union, lordships.
When the meeting is going to be held?
Lord, every day they are holding.
I think there is no. Lord, he is making a wild allegation. There is no specific meeting. He is not mention anything with regards to specific. What was mirrored? The opinion was sought for the Advocate General. Your Lordship has last time
time also.
And the Advocate General has stated there are 3 writ petitions are pending in 3 different High Court. Therefore, he said that there is the intercept dispute between even I and QC. He said, and taking all these things, he said that there is no legal compulsion to allow this person for joint, bipartite, or any statutory, non-statutory meetings. This is a omnibus order. So therefore, let us fight our counter. And the other case, other case is
on 30th On 30th, we will call. In the meanwhile, you file objection.
Yes, and you have to kindly call for the WPC 2009.
That's pressing urgency in the matter. I humbly pray, my lord.
You have given the papers only yesterday night.
Notice is served on 12th of February.
No, that was
other papers.
On the management.
Which you want to bank upon.
Everything.
No. Yesterday, can you say
not served yesterday. Kindly see, it is served long back.
No.
Yesterday you are up.
Yesterday, a copy. Additional affidavit yesterday.
That's on the question of interim prayer. Lord, your Lordship, kindly see the observation. Lord, Mr. Mahan, permit me that I am helpless. Kindly see my Lord the interim observation.
Mr. Ratho, one second. Now, you have given additional affidavit running into at least 20 pages.
But I
105 pages.
105. What I am humbly praying. Let them read
We'll
it.
call it coming week someday we'll call it. In the meanwhile, ensure that objections are made.
Yes.
You kindly see, Milord, there is another writ petition.
That also will call.
Connected. So your Lordship may what as Lordship proposes for 30th.
30th is very long.
Very long.
That is short date next week, Lordships.
This what we can do is instead we can on 24th we will have this matter.
With a small observation, Lord. In case the matter is not taken upon merits, my Lord, my interim prayer will be considered.
No, we'll consider.
Yes. Otherwise, this whole endeavor will be coming.
No, only interim prayer.
Because so critical.
Because other matters are pending.
Right, ma'am.
Heard.
I have filed intervention application.
You are also there.
Well, I have filed intervention application. That is IN number 4619/2020. I have already.
Let them file objections.
I'll file objection. I'll definitely complete it in the process.
Third, learned senior advocates, Ratho and Mr. Bhanti, and learned counsel appeals for three. So it's appealing for the intervener. First time. Ratho presses the matter, saying that there is a eminent urgency. First time. Bhanti seeks a short accommodation to file objection the application, interim application in IA number 4619 of 2026. First time. With the agreement of the parties, call this matter on 24th 2026 for consideration of interim prayer.
Right. So great.
Grateful, Lordships.
Item 12.
So, okay.
Item 12, WBC 5904 of 2026.
Yes.
Last occasion, Lordship has directed the bank to
on that day, I have taken undertaken to take in detail what happened in this case, my lord.
Yes.
Your Lordship, in this case, what happened? The property was sold.
Auction happened.
Thereafter, the auction was quashed by the tribunal DRT. And the auction purchaser has deposited the entire amount, which has been refunded to him. Initially 95 lakhs, it has been refunded. There are 2 lakhs, thereafter he has not taken the interest also.
Now tell us what remedy you want to.
My lord, my learned senior has filed the case stating that I am eligible to get the interest of the amount which has been deposited by the auction purchaser, my lord. How it is?
Auction purchaser has deposited 1 crore 12 lakhs, my lord.
Right.
Out of that, the irregular amount was 42 lakhs. That was deducted by the bank. But that was kept in a separate account, my lord. Instead of loan account, that was kept in a separate account.
Whose money it is?
It is my money, my lord.
Your money?
Yes, my lord. Because my property was sold to auction, my lord.
In auction, it was sold.
Yes. In auction, it was said, it was decided 1 crore 12 lakhs, my lord. Out of that, the irregular amount was put in, that was deducted by the bank, my lord, immediately.
Yes.
And thereafter, my lord, 18 it was deposited, 20 it was cancelled, my lord. 18 to 23 months, my lord, the balance amount was kept in a separate account, not in my loan account, my lord. For which, my lord, I
failed
My lord, it is an auction amount, and auction amount has been refunded to the auction purchaser after quashing of your lordship.
When?
Maybe
years?
after 2 years.
You are concerned.
He is concerned, my lord.
What has happened, my lord?
That is not his money. Because he wants to take the cream from the money of the auction purchaser. And now he has to pay the interest to the auction purchaser.
Whose money?
My property is in
It
my
was in the escrow account.
Yes.
Money was put in the escrow account.
Yes, ma'am.
Because of challenge.
No loan account.
It is not your money.
Yes.
Then, my lord, your lordship.
His money, it has gone back.
No, his money come back after 2 years, my lord.
After 10 years.
Yes.
How you are concerned with that? Where is your right, brother?
My lord.
We don't.
My property.
He has deposited.
My property.
That money is given back to him.
Yes.
Because the auction is settled. What is your right over the interest amount? He can claim interest. The person who had deposited that money, he can claim interest. Not you.
And he is not claiming it now also.
He is not claiming interest.
He is very gracious.
No, what?
If he will claim interest, then he has to pay.
I have filed an application. I have filed an application before the bank to calculate because
Well, now the case is pending before the DRT. Notice has been received. He can file an objection. He can file a
Case for dismissal with cost.
No, but your lordship see what is the amount?
Amount is 10 crore.
I'm concerned.
What is your interest on that?
That amount I am not concerned. I am concerned with the Annexure 4. Your lordship, Annexure 4.
Annexure 4.
Yes.
Possession notice.
Possession notice.
So it is 15,70,000
with interest from 17/12/2018.
How that was there, madam? Because your lordship.
And now.
Last occasion, your lordship is.
My lord and
your lordship, please. Your lordship has turned to page 17. Page 17. The auction purchaser filed a case, madam, before this honorable court for his balance amount, madam. Paragraph 4, madam. In response, counsel for the bank state that the branch manager concerned has obtained a sanction from the competent authority for release of the remaining balance amount of 15,70,000, which shall be positively remitted to this. This order was passed, my lord, on 4/5/2022, my lord. Thereafter, my lord, bank has sanctioned a loan of 15,70,000 from me, and it was deposited to the auction purchaser, my lord. That was after 4/5/2022, my lord. Now, customer see the notice, my lord. In notice, 15,70,000 is on since 17/12/18. Is on 17/12/18.
How?
That is.
My lord, it is the outstanding amount, and now no action has been taken till that against him. Now the OA has been filed for recovery of the amount, and in OA he has received the notice. He can file objection there and everything there because.
But till that is done.
No, my lord, there is no loan. Can he produce a document to show that thereafter it has been done? It is the outstanding amount as on 18 May, which has been.
Now you are not taking any action against him.
Not now.
We want to know.
My lord,
we will record that and we will dispose of the petition.
Yes, my lord, we have not issued any notice for auction or anything else. Till that.
No, that's all right. You are not going to take any coercive action.
No, now we are
processing.
No, I have not.
Now they have filed next page, Malo. Now they have filed. For an amount of 1,18 lakhs.
You challenge that.
If there is he can. We have not taken any action till now.
That no
reads as an.
Till now, your lordship may record.
After service of notice, the bank having entered appearance through its panel counsel submits that. Since OA number
438/2025.
438 of 2025 is pending before the DRT as also say number 81 of 2008.
No, that has been disposed.
That has been disposed.
That is not
pending before the DRT.
In view of that, amount has been refunded.
No coercive actions, no other coercive action for recovery will be taken.
No, will be not
taken.
Not been taken till now, as yet.
And therefore, petition is not maintainable. First up, he also tells that it is open to the petitioner all contentions before the DRT as have been taken before this court in the petition. First up, With the above observations, petition is dismissed. Yes. Okay.
That file was misplaced in fact. That I got it. May I pray, if I did adjourn, may I pray? It's a fresh matter of rate appeal because they are pursuing with the contempt. May I pray from Monday?
But I think order is already uploaded. Not uploaded.
Signed.
It's just monthly.
But take it out. Next week?
Monday, my lord.
Monday?
They are
I'll put it on Monday. That order.
for item 5. It's a state appeal.
The state appeal. Yes.
Item 13.
Yes. May I please, Your Honor?
Yes.
But the dispute is relating to grant of RSCP. The petitioner was appointed as statistical investigator on 17/3/82.
Serial number?
17/3/82, he was appointed.
1 second.
As statistical investigator. He joined
the matter? Yes.
He joined on 19/3/82.
You just community dates.
Yes. He was appointed on 17/3/82 as statistical investigator.
Appointed on
17/3/82. He joined on 19/3/82.
As
statistical investigator, Group C post.
Statistical investigator.
But since promotional avenues were not there for statistical investigator, after coming into force of that RSCP scheme, that is revised assured career progression scheme, my lord, he got 3 financial upgradation because his initial pay was in the post of statistical investigator, that is 9,300 to 34,800 with grade pay of 4,200.
34,000?
9,300 to 34,800. That is the pay band. And grade pay was 4,200. He was getting. My lord, he is entitled to get 3 financial upgradation as per the scheme on 10, 20 and 30 years. On completion of 10, 20 and 30 years. He was accordingly allowed that benefit by order dated 26/9/2013 under Annexure 5 that his first upgradation was first RSCP, that is in the grade pay of 4,600. Second,
4,600.
4,600. Because initially
GP became 46.
4,600. Pay was same. Pay 9,300 to 34,000.
RSCP 1 is 4,600.
On with effect from 1/3/2013. Because he opted for the same. It came into force with effect from 1/1/2013. He opted from that date. 1/3/2013. That is under Annexure 5 at page 29. Then second financial upgradation on completion of 20 years. That is in the grade pay of 5,400. Pay band was same.
Grade pay is
5,400 on completion of 20 years. Second upgradation.
So that is with effect from?
Same date, 1/3/2013, because he completed 30 years prior to 1/1/2013. That cut-off date.
No, up to 1/3/2030. From if it effect from 1/3/2013, he was getting 4,600.
4,000 he was given first RSCP.
Correct.
That is a grade pay of 4,600. Prior to that, he was getting grade pay of 4,200.
4,200.
Next upgradation, that is first RSCP.
5,400.
No, 4,600. First
RSCP.
RSCP. Then
second RSCP?
5,400.
5,400 with effect from which date?
Same date, 1/3/2013. Because he completed 30 years of service prior to 1/1/2013. The scheme came into force with effect from 1/1/2013.
So both the grade pay on 1/3/2013?
Yes. Because he completed 30 years, 10, 20 and 30.
82, 92, 2002, 2012. So 30.
Prior to 1/1.
So all the three GP, the RSCP are given on same date.
Yes, same date. That is 10, 20 and 30 years of service.
Correct.
Then my lord, the second RSCP 4,600.
Third is
first RSCP 4,600, second RSCP 400, and third is 6,600. Pay band is the same. That is 9,300 to 34,800.
Grade pay is?
Grade pay, my lord, I have said the first RSCP.
Understood. Last one, third one.
Third one is 6,600.
Okay.
My lord, this is in consonance with the Finance Department resolution dated 6/2/2013. Your lordship may kindly turn to Annexure 2 at page 19, that RSCP scheme.
Page 19.
Page 19. That resolution dated 6/2/2013. Paragraph 3.
All this is paid pursuant to this resolution.
This resolution, taking into account the uncertain promotional avenues, paragraph 3, and career stagnation of the state government employees, government after careful consideration have decided to implement a career advancement scheme to be known as Revised Assured Career Progression Scheme, RACPs. The RACPs is to be effective from 1/1/2013. Then your lordship may kindly come to next page. Then the para 1. There shall be 3 financial upgradations under the RACPs counted from the direct entry grade on completion of 10, 20 and 30 years of service in a single cadre in absence of promotion. An employee, if completed 10 years of service in the entry grade, he will be considered for first upgradation under RACPs. An employee completing 20 years of service and has got only one upgradation, either by promotion or by RACPs, will be considered for the second upgradation. Similarly, an employee completing 30 years of service and has got 2 upgradation, either by RACPs or promotion, or both, will be considered for third upgradation under RACPs. Then
why they are using the word promotion? RACP is given when promotion is
not there. Stagnation.
Correct.
Stagnation. Here, my lord, the petitioner has not got promotion. Admitted, yes.
No, I was just saying
yes.
This is the wrongly worded.
Yes. Then, my lord, the para 2 is important. The financial upgradation under the RACPs would be admissible up to the highest grade pay of 7,600 in the pay band of pay band 3 under ORSP rules 2008.
7,600. Your 3 was 5,400.
No, my lord, 3 is 6,600. 6,600.
Yes.
Then your lordship may kindly come to para 8. Because the trial judgment is basing upon this. Para 8.
Pay band 3.
The pay band 3. Ours is, mine is pay band 2. Because I am a Group C employee. This is meant for...
Pay band 2 is 9,300.
Yes, pay band 3, that is 15,600 to 39,100 with grade pay of 5,400, being the Group A entry grade pay band, shall not be allowed under RACPs to an employee in pay band 2. For example...
No, why were you before the tribunal?
Well, because, my lord, after I got the first, second and third RACP, that is 4,600, 5,400 and 6,600, the screening committee, without giving me any notice, my lord, reduced my third RACP to 5,400. I challenge that
to 5,400.
5,400.
Why?
My lord, they say that this great pay of 6,600 is meant for, my lord, the Group A employees.
No, no.
No,
That is not even.
Yes, yes.
8 is not that.
My lord,
8 is
8
not
is
that.
not that.
where is that order?
Yes.
Said like this.
Your lordship may kindly come to the tribunal's order.
Not tribunal's order. You went to tribunal, why?
Well, because your lordship may kindly see the decision of the screening committee.
That we want to see.
Yes. My lord may kindly come to Annexure 6 at page 31. The second paragraph. The screening committee re-scrutinized the RACP, so allowed in 3 stages in favor of Lakshman Kumar Padi, the present petitioner. SI/auditor of this office, by this office, order number such and such, dated 26/9/2013. Pursuant to screening committee resolution number 2, dated 26/9/2013, and after due scrutinization of the service book of Sri Padi, and after thorough discussion on the guidelines in government orders / clarifications issued from time to time by Finance Department, S&ME Department, Government of Odisha as above, it was ascertained that grade pay allowed inadvertently to Sri Padi in the 3rd stage, 6,600. As such, the committee decided to cancel the order as above, and he is entitled to grade pay.
You were not given opportunity of hearing.
No opportunity.
Why, brother, no opportunity of hearing? All of a sudden you reduced the grade pay to that extent. And recovery ordered.
A recovery ordered, and recovery was also made after my retirement. Of course, because since I was getting provisional pension after my retirement, my lord, I filed one IA before this honorable court that by deducting that amount, my final pension may be released. That is without prejudice to my claim in the writ petition. That order is there.
Did you take up the contention that you were not
yes.
given opportunity of hearing before the tribunal?
Yes, yes.
What? No, this are it. You have said that.
Yes, your lordship may kindly see. And the learned tribunal has also answered the same. The learned tribunal has said that no opportunity is required.
Because if it is given, it will not change the position.
Yes, but your lordship may kindly see the judgment of the tribunal.
No, an opportunity has to be given.
No, my lord, they say that since I have furnished an undertaking,
whether it is inadvertently or not, I might have furnished undertaking saying that in the event I draw more than what I am entitled to, I will give back. Correct. That does not dispense with hearing opportunity.
And that is the judgment of the Honorable Apex Court.
You will remit the matter for reconsideration. You give opportunity. Let them give opportunity. Decide it within 8 weeks. Within 3 months. Because that was your case before the tribunal.
That is the case. So far as
you can take up all contentions.
But so far as recovery aspect is concerned, well, the latest judgment is Jogeshwar Sahu.
Jogeshwar
Sahu versus the district judge Katak and others. Where all the judgment, Thomas Daniel, Rafiq Masi and others, your lordship may kindly see that.
This recovery is done after retirement?
After retirement.
No, before retirement.
No, after retirement. I retired from service on 31/3/2017. The tribunal decided on 5/10/2018.
The Rafiq Masi is Group D.
No, Group C and Group D.
Group C and D.
Here also Group C and Group D. Your lordship, this is the latest. This is the latest.
This is the
Group C.
Statistical investigator is
Group C.
At the initial stage.
Group C. Your lordship, kindly.
Group C, when the recovery was made, in which group we were?
The same group, that statistical investigator. Para 18 of that judgment, your lordship may kindly see. Under what circumstances recovery can be made? Para 18.
18, 1 or 2?
1/8. Well, I also come under 1 and 2 also. Recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. And the recovered amount is 62,783.
And 1 and 2.
1 and 2. And so far as opportunity is concerned, That is state of Punjab versus the senior.
That is there. That
Your Lordship may kindly see any financial
benefit is already accrued.
Yes. And here, my lord, if 5400 is retained, then I will not get third upgradation, financial upgradation.
That 6600.
Yes, Your Lordship may kindly see, after the recovery order was passed, my lord may kindly see my rejoinder, how they have fixed my RACP. That is...
No, what we are thinking is, since you have taken up a contention that all this has been done without giving an opportunity of hearing, we will remand the matter to decide it afresh after 2 months. You take up all contentions, then let them pass order. What all other things
I pray you not to decide on merit.
No, we cannot, because firstly, we do in one case, that becomes the precedent for rest of the cases. We do not know what has been done in the matter. We cannot know. It's all departmental matters where department should decide.
I would be able to convince your lordship that I am entitled to get third RACP, that is 6600.
No, that we can claim before them only. That contention you can take up before the concerned authority.
And my lord, so far as recovered amount is concerned, there should be...
But if you succeed there, then it will be. Otherwise, it will be with them only. But they will direct them in the event.
But in any event, but even if I do not succeed before the authorities, then also that amount cannot be recovered from me. In view of the judgment of Yogeshwar, Thomas Daniel, Rafiq Masi. Because there is no misrepresentation or
from the side of
any separation of facts.
The screening committee did it on its own.
On its own. That is my case, and the learned tribunal has, your lordship may kindly see the findings of the
tribunal considered.
Yes, the tribunal has considered that since I have furnished an undertaking, so therefore there is no
substitute.
That inland water, that my lord. That
but
is
the undertaking aspect is not decided.
No, undertaking aspect has been taken note of by the learned tribunal.
No, tribunal already. In apex court judgments, wherever undertaken,
yes,
that is not taken care of by any judge.
That has not been taken care of.
Yes. Therefore, we are remanding the matter for fresh consideration. You have given undertaking.
Yes.
In those cases, there was no undertaking at all.
But in all cases, that is the usual practice. In all cases, they used to obtain undertaking.
No, in Rafiq Masi, Justice Kehal's judgment.
Well, Rafiq Masi, there was no undertaking.
There is no.
But so far as financial upgradation is concerned, in all cases, they used to take undertaking.
But now, this factor was absent in all the three cases. Rafiq Masi, Yogeshwar Sahu,
Thomas Daniel,
in all these three cases, there is no reference to any undertaking.
But the ratio of those judgments is that after retirement, no recovery can be made. If there is no misrepresentation or...
No recovery can be made, even if there is a representation, the undertaking is given. That is not the law.
No, that is not there. You are absolutely correct.
Absent the undertaking.
Yes.
Those judgments are applicable.
Well, so far as inland, that judgment of the Honorable Apex Court is concerned, well, that undertaking, if it is not between the equal bargaining power, that is no undertaking in the IF law.
Then why did you give that? We can't take it to that level. In inland water, workmen inland water so and so.
Yes.
The case was, the court went on a bargaining power.
Yes.
Equal bargaining power was lacking. There was a case of...
That is a contract between lion and lamb.
Not your case.
Lion and lamb.
Correct. But in your case, you are already in employment. And recovery is made after retirement.
After retirement. That is not permissible.
No.
That is not permissible.
No, that undertaking was given when you were in employment only.
Yes.
You had
that while providing RACP.
Take note. Petitioner a retired statistical investigator is kindly be seated. Yes.
And this is the order by virtue of which recovery was made.
Knocking at the doors of Writ Court for assailing the Orissa Administrative Tribunal's order dated
That is dated
27,
5/10/2018.
5/10/2018,
Annexure 9.
whereby is way number 3131C of 2015 has been negatived. First, in the said OA, he had called in question the screening committee's endorsement dated 27/5/2015, whereby his third stage RACP was reduced from 6,600 to rupees 5,400 on the ground that it was wrongly conferred on him. First, learned counsel for the petitioner canvassed twofold argument. A twofold argument for voiding the order of the tribunal. Firstly, the cadre of the petitioner is Group C, and therefore, post-retirement, no recovery could have been ordered, whether his grant was made rightly or wrongly. First, in support of this, he presses into service Apex Court decision in Jogeshwar Sahu versus the District Judge Cuttack 2025 INAC 449, more particularly para 18 sub-paragraphs 1 and 2. Secondly, recovery of the kind could not have been made sans an opportunity of hearing, in as much as recovery is a civil consequence which cannot be brought about in violation of principles of natural justice. First, learned ASC appearing for the OP resist the petition, making submission in justification of the tribunal's order and the reasons on which it has been structured. First up, he tells that the Jogeshwari decision is not applicable to the case in as much as petitioner has admittedly given an undertaking to refund what is not he is entitled to.
68 of the pension rule also speaks recovery.
He also quotes Rule 68
of the pension rule
of the Pension Rules 1992 in support of the impugned order. First, having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence in the matter as under and for the following reasons. Number one, petitioner was appointed as statistical investigator on 17/3/1982 and he reported for duty on 19/3/1982. First time. Initially, he was in the pay scale of rupees 9,300-34,800 with the grade P of rupees 4,200. First term. Pursuant to the RACP policy, he was granted RACP1 RACP1 grade pay of rupees 4,600 and RACP 2 grade pay of rupees 5,400 and RACP 3rd grade pay of rupees 6,600, first one. All this was with effect from 1/3/2013 all this was with effect from 1/3/2013 in as much as by that time he had already put in a long and spotless service of 30 years. First one. The policy, it hardly needs to be stated that the first RACP is after 10 years, second after 20 years, and third after 30 years. First one. Next point. It is not in dispute that the petitioner was not given an opportunity of hearing before the screening committee took the decision, maybe after verifying the factuals. First, even God is said to have given an opportunity of hearing to Adam and Eve before punishing them for eating the proscribed apple in the Eden garden. First, if that be so, we fail to understand why no opportunity was given to the petitioner before directing the recovery pursuant to impugned order of the screening committee. First, thus there is gross violation of principles of natural justice, and therefore order the recovery needs to be settled. First, next paragraph.
Recovery and reduction of grade pay.
Reduction of grade pay and recovery have to be settled. First, next paragraph. The above being said, there is force in the submission of learned counsel for the learned ASC that in Rafiq Masi or in Jogeswara Sahu
and Thomas
Daniel, just give the citations.
In that case,
there was no undertaking given by the employee while taking the benefit of the kind, and therefore the ratio in the said decisions cannot be applied, cannot be invoked by the petitioner mindlessly. First, a decision is an authority for the proposition that is done in a given fact matrix of the case, not for all that, which would logically flow from what has been so laid down, said Lord Halsbury in Quinn versus Lytham, 1901, AC, so and so, so and so. First off, once the undertaking is given, it cannot go with the impunity. First off, the submission of Mr. Swain that the undertaking was obtained by the employer in not equal bargaining power, and therefore keeping in view the inland water so and so, so and so. So, it is liable to be ignored, and the and further the ratio of Rafiq Masi it becomes invocable, is bit difficult to countenance. First, in inland water, the doctrine of equal bargain was invoked because invoked in a different fact matrix than here. First, it was a case of breadwinning, in as much as the very employment of the employees concerned was at stake. First up. Therefore, this contention cannot be accepted. Next paragraph. In the above circumstances, this petition succeeds. Second, a writ of certiorari issues, quashing the impugned order of the tribunal. Second, impugned order of the tribunal. And also, the decision of the screening committee,
Annexure 6.
Annexure 6 to the WP. No. Writ appeal annexure, no.
Yes, writ appeal.
That was challenged in this one, no?
Yes.
What was
I have annexed also.
here also?
Yes.
At annexure
6.
6. At annexure 6. First up, matter is remitted to the portals of
OP number 3.
OP number 3 for consideration afresh after giving an opportunity of hearing to the petitioner, within an outer limit of 3 months. Next, it is needless to say that in the event, all cases are approved. No costs. Yes. Okay. Next. You give citation of Inland Repicmacy.
Yes. Thomas Daniel, I have given.
Yes. Jogeshwar Sahu is.
Thomas Daniel, I have given.
Yes. Inland Water also.
Yes.
Repicmacy 2014.
Yes. Inland Water.
Yes. Inland Water is 1980s.
That is 86.
86 Supreme Court. Correct.
86.
Weekly list item 41. Writ appeal 433 of 2025.
Yes, sister. 21.
My lord, there is a 120.
Serial number?
Item 41.
41.
Pardon, my lord. There is a delay of 127 days in filing this writ appeal.
Make use of the mic. Your voice is weak.
My lord, there is a 127 days delay in filing this writ appeal.
What is the matter on merit? Tell us.
Yes, my lord. My lord, this old lady.
41, sir. 41.
My lord, this old lady seeks compensation from the government of Orissa upon 2 distinct and separate heads. The first one is medical negligence, and second is rejection of her CMRF application. And learned single judge confused both the heads. First of all, my lord, kindly come to the Annexure 2 of this writ appeal, which is the original writ petition.
What is wrong with this order? He has directed constitution of the committee.
Yes, my lord. My lord, this constitution is
expert committee comprising of 3 members.
Yes, my lord. But this committee is headed by Directorate of Health Service, and he will direct the additional secretary to Home Department, to his senior.
Now, what was the case actually?
Is this old lady's husband has a problem in his lymph node, and in his
husband died of wrong diagnosis.
Wrong diagnosis.
You have come for medical negligence.
Wrong treatment. So
treatment in the.
He has a cancer, but he is treated as dots from TB. Though there is a confirmatory test that he has no TB. And they refused to refused for test and shifted the patient from this department to that department, and persuaded to go through DOTS treatment.
by the Acharya Harira.
They are a government medical institution.
Yes, my lord.
Not all right. What is wrong? He said, let the committee take a decision. Expert committee is necessary. And we have not studied medical
The
science.
committee is earlier also established and they tried to cover up the matter.
Earlier committee?
Earlier committee tried to cover up the matter.
Therefore, new committee is constituted. How can we decide? Neither my brother is a doctor, nor I am.
My lord, your lordship is the expert of experts.
No, that good, very, it sounds very beautiful to us, hearing such even when false statement. We feel
No,
very
my lord,
happy.
the prescriptions are very clear.
Huh?
The prescriptions
are very clear. All right.
We judge.
Medical negligence is a technical.
How can we judge? What is how whether it's TB or carcinogenous disease? How can we decide? Therefore, committee is constituted.
My lord, before drafting this writ, I had consulted two independent doctors and they had clarified me the technical terms. I am not also.
Therefore,
thereafter I drafted this.
Sorry, we appreciate that. We have inherent limitations. Even if we have knowledge of medical science, we cannot infuse it into our judgment. We can express it in a bar or in the function exercise, another thing. But expert evidence, if you see how section 45 of the Evidence Act is coined, and Phipson's discussion, why such expertise is necessary, you will know its importance. What cannot decide? There is no wrong in that.
My lord.
They have fixed a timeline.
My lord.
The thing is, how can we decide? Where is the material to decide that there is medical negligence?
Yes, my lord.
Which is that?
My lord, Annexure 8 to Annexure 12.
What are they?
Annexure 8 is Annexure 8 of the original writ petition.
Annexure 8
to the original writ petition, that it is.
Annexure 8.
Annexure 8 to the original writ petition, that is.
Correct, but it's a prescription.
Yes, ma'am.
We can read it also.
I am showing one after another to you.
No, even first we cannot understand, let alone another. How explain it? You tell us what is that? Let us see how she will read it. Read it now. That medicine is given for which disease? What is the dosage? And which is the manufacturing company? What are the contents of this medicine? How they operate the physiology of the man? Explain us to us.
My lord, Annexure 8.
Come on, take 8 now.
8.
Explain now. What is this medicine?
That is the last word, LNLT.
Means what?
They advise for DOTS treatment and ITD. DOTS treatment.
Means what?
They diagnosis TB in the patient and prescribed for DOTS.
What means what? Prescribed for DOT means?
DOTS mean a direct treatment. That the surgeon, their authorities come and they directly induce the medicine to the patient.
No, but how we can decide all this? No,
DOTS is a direct treatment to the patient.
Certain area we cannot handle.
It is not our domain.
Opinion.
It amounts to asking the judges to fly in the flight which we do not know how to pilot. If something happens to the flight and the claims come for damages, etc., we can decide is another thing. But that we cannot do by sitting in the cockpit.
This is the first ground. Yes, my lord. Your lordship, the first ground. That there is a misdiagnosis and wrong treatment. Thereafter, the patient goes for private treatment.
Now, how can we decide? You are not telling that point. How can judges decide? We cannot infuse our private knowledge into the matter. Private knowledge maybe that we have studied out of interest, the anatomy, famous anatomy,
And jurisprudence also.
That medical legal jurisprudence by Moody, etc. They are totally very frugal knowledge we will have in that. Grace anatomy, etc. Out of curiosity we read, but we will not be able to grasp what all he says.
Yes, my
So,
lord.
if it goes before the committee, committee will take it.
Yes, my lord.
Not relief to you. Learned judge has not relief to you. We would have sent you to the consumer forum actually.
My lord, I will not cover with consumer forum as it is a government hospital.
Government hospital.
Yes.
So, learned judge has said, the committee decide all those things, and based upon that report, things will be taken care of.
My lord, but according to Annex 2021, the wide there is a survey upon the patient that yes, he is in cancer, and his CMRF sanction was also held. Does not granted the money from the CMRF.
After medical negligence, how can we assess it? Again, the whole question will be before us.
That are no ultimately.
Expert committee's report has to be there. Then the question of appreciation will come.
My lord, in the original read, they filed a report that the patient is incooperative. That is why they could not.
That is how Lordship said that yes, court has considered your application and wanted another committee to be constituted for the purpose.
For the purpose.
Court is also not satisfied on that, accepting your prayer.
My lord, again, if your lordship pleases to listen me.
Oh, we'll be pleased to listen you, but bit thoroughly you can complete your argument. If you have decided till 4 o'clock, we will listen to you because we have no options.
I am obliged, lordship. In Annex 3, I am categorically stated in my written statement, in my written note of arguments, that this petitioner seeks compensation with two distinct heads. The first one is illegal rejection of CMRF application, and for that we have added opposite party number 1 to 5 as parties, and they, despite of several reminders, they did not file their counter. It implies that they admitted my claim.
If WS is not filed, plaintiff is admitted.
Implies that.
No, not like that. To some extent. So the foundational facts have to be placed before the court.
Judgment it must at once.
He was suffering from cancer.
Yes, ma'am.
What cancer it was?
The lung cancer.
Lung cancer. What was the stage of the cancer? What stage it was?
It's the third stage, is died. Yes, ma'am.
Dead.
The patient is dead, and for that,
No, not in lungs, it was in tonsil. It was
lungs and tonsil. Despite of
What is the operative portion of the earth?
yes, my lord. Conclusion at page 44 of this writ application. Considering the facts and circumstances of the present case, this court holds the view that the matter should first be referred to an expert committee comprising of 3 members who shall be tasked with determining the validity and implications of the of the imputations presented herein. Second, the Director of Health Services is hereby ordered to establish and participate in a 3-member committee, including medical experts from neutral third parties, for the thorough examination of the case at hand. This committee shall be responsible for thoroughly examining the factual accuracy of the arguments presented by both parties. In the context of medical negligence, the committee's role is crucial in ensuring that all claims and defenses are supported by concrete evidence and established medical standards. Their assessment will provide an informed and impartial foundation upon which the court can base its decision, ensuring that case is reached.
Dr. Panigra has considered all aspects of the matter.
Then he has not fixed a date.
Huh?
But he has not fixed a date.
Fix a date. We'll fix the date. Within what period this should be? That ought to have been done. Otherwise, government being what it is, the matter, and your client will not get any relief. That we will do. In a time-bound way, all this should be done. That we will do. To that extent, you will succeed. Timeline to be fixed.
Well, in this is also that the issue concerning the rejection of the compensation amount by the CMRF office shall be resolved upon the establishment of this committee.
Report.
Opinion. But CMRF office is additional commissioner.
Huh?
CMRF office is
what is meant by CMRF office?
Chief Minister's
Chief Minister's Relief Fund Office.
The Chief Secretary and Chief Development Commission.
We'll put it in a long term, long form instead of short form. There shall be no confusion. These two things we can do in your opinion, nothing beyond that. What is that? The committee will comprise of experts. Expert body will examine everything. It will form opinion as to whether there is medical negligence or not. Based upon that report, Chief Minister's Relief Fund can be invoked or not will also be decided.
My Lord, Chief Minister's Relief Fund is already decided that this patient is eligible to get relief.
Very bad.
It is annexed to 21 to the in guideline.
Office of the Revenue Inspector's Other, 21.
I'm sorry, ma'am. From Annex to 20, 21, and 22, and lastly 23. This is there is an extensive inquiry that whether the patient is suffering from cancer or not, and how much money he has spent. Thereafter, the collector directed the CMRF office to be
80,000 rupees.
Yes, ma'am.
That amount is not paid to you.
Nothing is paid.
What do you say, Mr. Behura? There is a office of the collector, district magistrate Cuttack. Collect recommended medical has incurred an expenditure of 80,000 towards treatment cost. Also, I do hereby recommend this case to your good office for sanction of. See, this is not on medical negligence. It is on citizen is suffering. Therefore, king has to do something on that principle. It's in the nature of ex gratia. Why that is not paid to her?
Take instruction whether it is paid or not.
I will call this matter tomorrow.
Monday.
Call this matter. And I think issue notice the heard, Madam. So the case is made out only to the limited extent at this stage, only to the limited extent of considering that the relief under the Chief Minister's Relief Fund, as recommended by the Cuttack District Collector. Correct. To stop. Learned issue notice. Learned AGM Mr. Behura is requested to accept notice for all ROPs. All first one. He has to make statement as to why the government has not sanctioned a sum of rupees 80,000 to the appellant widow, despite there being a recommendation by the Cuttack collector. Why the letter dated
375 dated 21/2/21.
Dated annexure 23.
21 to 21.
Yes. Let us.
Letter number 375.
Sir, copy is served. Copy is served. Yes. See, there is a recommendation.
My lord.
He has lost her husband.
I want.
And DC has said, give money. That you have to.
What action is taken?
What's not action? Why is not paid?
Preliminary, my case is against OP 1 to 5.
Let us first get to pocket that money.
Yes.
Yes.
Noticed item 42, Rate Appeal 472 of 2025.
Pass over. 2 weeks. Next.
Item 43, Rate Appeal 502 of 45.
44 वालों से 2 minutes Hon'Ble already
2 weeks. At the request of ASC. Next.
Item number 45, Rate Appeal 603 of 2025.
Yes.
So there is a delay of 41 days, man. The case of India has filed this case. Indian of India has filed this case challenging the order passed by the Honorable Singh.
What is the effect in the order?
Effect that what happened? The opposite party respondent, while working as a constable in the year 2005, a criminal case was initiated against him due to some against the lady, for which a FIR was lodged under him under section 41, 354, 506, 509 IPF. Thereafter, the respondent deserted the office unauthorized absence from 1 to 2000, from February 1st, 2005 for a period of 172 days, for which we have initiated disciplinary proceeding against the respondent.
174 days.
172 days.
172 days. Is it unauthorized absence or desertion?
Desertion.
Deserting the armed forces.
Deserting the office. Deserting the, because misconduct, indiscipline and unbecoming member of regimented force like CISF. So we have issued a disciplinary proceeding notice against him. The disciplinary proceeding was ended as a punishment for removal of serviceman. Thereafter, he approached the appellate authority. Appellate authority also dismisses appeal. Thereafter, revisional authority also dismisses revision. Challenging that, he has filed a writ application before this honorable court, my lord. The writ application was 8161 by 2009. While this writ application was pending,
1 lakh rupees compensation is ordered.
Here what happened? When earlier writ application was pending, the criminal case was acquitted, for which the writ application was.
No? Did you take any disciplinary action against him?
This disciplinary action matter for removal of service.
You have taken.
We have removed from service.
One by one. In the criminal case, is it honorable acquittal or acquittal for want of evidence?
Want of evidence, because the lady did not come forward to adduce evidence.
That lady, what is her age and what she was doing? That's all important. That lady, see, she is in the matrimonial market. She will not come because her matrimonial market will be affected.
No, I am not on that. Subsequently, what happened? The writ application was remitted for reconsideration to the department. We have the punishment was modified to the extent that the removal order was withdrawn, and with punishment was given withholding of 1 increment for a period of 3 years, which shall have the effect of postponing his future increment. So removal order was withdrawn. Only the punishment for withholding one
with
cumulative effect that was awarded.
In matters of outraging modesty, women do not come forward and they cannot come forward. We will issue notice. Take notice. Issue emergent. Any contempt or anything?
Contempt was contempt.
Issue emergent notice. Returnable within 3 weeks. First round. It is open to the petitioners to move the court in the event any contempt or coercive action is taken pursuant to impugned order. So notice both on main matter and delay application. Okay.
Item 46, Rate Appeal 659 of 2025.
Please, Your Lordship. Lordship, with the change in counsel, so if instructions to appear will file wakalat now.
Next.
Grateful.
That's the request.
Item number 47, Rate Appeal 666 of 2025.
Lordship, I am for the respondent. Due to copy may be solved, Your Lordship. Lordship, I will file objection to the condonation of delay petition, Your Lordship.
How many days delay?
311 days delay.
You accept money and what objection you will file? Government, your government will always work that way only, na? Cyclone and other things, even after the cyclone is over, they will do everything. But in advance, they will never do it.
File a formal objection, Your Lordship, let it taken up 2 weeks after the
3 weeks. That's the request now. Next.
Grateful, Lordship.
No 48.
But once you file objection, then no cost, nothing. We will consider on merits and we will do. If you say, we will direct them to 20 rupees per day. Think, then once you file objection, then we do not know what we are going to do.
What's going on?
Money attracts. Anyway, you decide it.
Item 48, Rate Appeal 1107 of 2025.
Huh?
48.
3 weeks at the request of.
Item 49, Rate Appeal 1218 of 2025.
Passover for the day.
No Passover, 3 weeks. Next. If you are ready, we will hear the passing over.
Item number 50, Rate Appeal 1229 of 2025.
Item 50, State Appeal. I am appealing for respondent.
Yes. Yes, brother.
A copy of the Rate Appeal and the limitation petition may be served.
Limitation is how many days? 229 days.
Yes. With that cost.
Yes, brother. 229 days. At 20 rupees. This appeal, this intra-court appeal is moved by the state and its officials against order of the learned single judge. First up, they have proved a delay of 229 days in filing the appeal and an application in IA number 3113 of 2025 accompanies the appeal memo. First up, it is supported by an affidavit. Some explanation has been offered for the delay with which you are not fully satisfied. First up, in matters like this, we have awarded a cost of ₹20 per day of delay for favorably considering the request for its condonation. First up, in the above circumstances, application having been favored, delay of 229 days is condoned, subject to the appellants collectively paying how much it will be? 229?
4,580. 4,580.
Rupees 4,580 to the respondent employee.
I am not in service.
To the respondent within 3 weeks, failing which the application shall be deemed to have rejected and as a consequence, the appeal as well. First up, call immediately after 3 weeks. 3 weeks. Okay. No, this is
Notice maybe issued in that.
Yes, issue notice. Issue notice. Take notice. Let us see. Issue notice. Mr. G, learned AG is requested to accept notice for all OP.
Yes, ma'am. Yes, ma'am.
Okay.
5 पे अपन ने ना patra na.
Yes.
5 पे. And on so as per number 5 is concerned, I will serve on Sudhir Kumar Patra. Normally he appears.
Sudhir Kumar Patra, AG panel cell. AG is requested to accept notice for R5. R5.
Item 52.
1, 2, 4, 3.
Rate Appeal 1477 of 2025.
The only hope of safety on this case probably has fallen down. Yes, 52.
Yes, sir.
Yes, ma'am.
University we know. It competes with the government in delay and other things.
Mr. Kuntia, you are the panel lawyer, not here?
It is proposed that university panel, that panel will
all be reconstituted.
It will be reconstituted except Saswadas all have been disengaged. So the register has requested me to continue till so your lordship has seen that in the earlier case I was requesting for an adjournment.
Yes.
Mr. Saswadas is continuing.
He is continuing. So
he is continuing. Except Saswadas all are disengaged. I'll intimate Mr.
Das.
Yes, ma'am.
3 weeks to our counsel for this panel counsel for the university to come and argue. Yes.
Item 53, Rate Appeal 1506 of 2025.
May I please proceed?
Yes.
Here the register has shown the delay as 302 days, my lord. But it was not within our knowledge. When we received the notice from the Law and Trial Court, it came to our knowledge. Though we are a party in the writ application, but notice was not issued to us. At the time of admission, it was disposed of by the Honorable Single Judge, my lord.
How much delay there?
Delay will be, it came to our knowledge on 16/5/2025.
Office says about 302 days.
302 days.
Yes.
On merits, what you have got?
My lord, your lordship may kindly see Annexure 1, that is the impugned order. The Honorable Single Judge at Para 5 has directed that you approach the civil court. But the civil court jurisdiction is barred under law, my lord.
The court jurisdiction is barred?
Barred, my lord.
What was the dispute?
Dispute is, my lord, the opposite, the respondent number 1 made some permanent construction over a passage, my lord.
Over a passage?
Passage, my lord.
Common passage.
Common passage, my lord. The people of the locality challenged. The demolition order was passed in 2014.
Under section 91.
My lord. Then he preferred an appeal before the appellate authority.
91.
That was 2. Yes, my lord. That was disallowed. Thereafter, the
appeal is dismissed on what ground?
That it is correctly passed. Order is rightly passed by the CDA authorities.
No, the authority passed section 90, clause 1 order.
My lord.
What it said?
Said that he has constructed without obtaining any permission from the authority. That is illegal. On that ground, it was, or the demolition order was passed.
Take notice. Let us issue emergent notice. State is party.
Opposition or one.
Mr. G, learned AG is requested to accept notice for R2.
Up to 1 only.
No, you are R2 only.
Only R2. Emergent notice to rest of the parties. Any panel counsel is there for
CDA?
Yes, my lord.
Mr. Mahapatra was there.
There is no more there.
That's all right, you take notice.
I will take
emergent
notice.
Returnable within 2 weeks, 3 weeks.
Item 54.
Oblige.
Date Appeal 1507 of 2025.
Any returnable date file?
Dates we are not given, but 3 weeks we have said. Let them serve, let them be served. But there is one famous judgment on that. AR 1969 Supreme Court, page 78. When civil court's jurisdiction is ousted, it's a very beautiful judgment by Justice Hidayatullah. Just look into it. Okay.
Your Lordship, pass over for the day. Preparing for it.
State. Yes, Mr. G, what is this matter about?
I'm challenging the order passed by the Remand. No single judge manner. I am before your Lordships.
All appeals are against single judge's order only. Yes. What is the
direction was
order dated 28/10/2015, passed by the commandant, is set aside.
Its petition is
To
allowed
reconsider the petitioner's case and render a judicial decision about their reinstatement, taking into account the observations made in this case as circumstances.
to Homeguard, my lord.
This matter is remanded.
Remanded back.
Even on remand also, appeal is maintainable.
No. It is a case of reconsideration.
Yes. Reconsider it in time to show you that. That is not.
Matter may be taken up tomorrow.
Why?
Because my associate has failed.
Where you are? Have you entered caveat?
No, I am the
Notice was issued to you. Huh?
caveat to have filed.
Caveat you have filed. No, in case of remand, where is the scope for interference? If it is absolutely, we can understand. They have said judicious order is not made. Therefore, commandant being the statutory appellate authority
is to reconsider it again.
All contentions are kept open to you.
No, my lord. No, my lord. That was quashed. Enter the dismissal order as well as the appellate order was quashed.
Correct. After that, matter is remanded.
And with a direction to consider.
Even against such orders, they are in appeal now.
And then
you are not in appeal.
No, we are not.
You are not in appeal. Therefore, you are going to go to the body, appellate authority.
Since it was quashed, both the orders was quashed. So, and they did consider it. So, when we filed a contempt, after filing of the contempt,
you have filed the appeal.
They have filed the appeal. Badly, by limitation. So I don't have the records minus, so I am praying for tomorrow.
No, you are passing order in your favor. You don't want order in your favor today. Anything to be received, consideration to be received from the client.
Since I don't have the file, so that's why.
Take down. This intra-court appeal by the state and its officials, kindly be seated, seeks to call in question a learned single judge's order dated 29/10/2024, whereby respondent employees WPC number 11059 of 2018 having been partly favored, the orders that were challenged in the said writ petition having been set at naught, matter is remitted to the portals of the statutory appellate authority, that is the commandant, for consideration of freshly. First off, learned single judge has also directed to pass a judicious order pursuant to the remand. First off. Next paragraph. Learned AGA appearing for the appellants submits that there was absolutely no case for remand, not for interference of the learned single judge in the fact matrix of the case, and therefore indulgence of this court is eminently warranted for setting the injustice at naught. First off. Learned counsel Sri so-and-so appearing on caveat for the respondent employee opposes the appeal, making submission in justification of the impugned order and the reasons on which it has been structured. Next one. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, inasmuch as the learned single judge having set aside the penalty orders,
Penalty as also appeal.
punishment orders, has only remanded the matter for fresh consideration at the hands of the statutory appellate authority. First off, this he has done because of absence of judicious reasons in the penalty orders and also the first appellate order. First off, such orders of the learned single judge are generally not amenable for challenge in intra-court appeal, in as much as all contentions of the parties are kept open. First off, what prejudice has been caused to the appellants has not been demonstrated despite vociferous arguments. First off, next, in the above circumstances, this appeal being unworthy of merits is liable to be rejected, and accordingly it is. Costs having been made easy. First off, the remand to be accomplished within an outer limit of 8 weeks. 8 weeks. And order shall 8 weeks after giving an opportunity of hearing to the respondent employee. First off, if delay is proved, the same shall be viewed very seriously in the next level of litigation.
I may be pardoned. After we filed that contempt, they have filed an application. They have taken a decision, reiterating whatever they took that they are not.
That you have to challenge. We cannot do it here. Because after contempt, they have passed that order.
No, when contempt was filed,
they have passed that order.
They had passed that order.
That you have to challenge.
When
now that order is complete.
Say, for that reason, I am
we make it clear that question of considering the remand would arise if it is already not considered. Okay. Next.
Item 55, Writ Appeal 1532 of 2025.
2 weeks. 3 weeks. That's the request of.
Item 56, Writ Appeal 1534 of 2025.
56. Mr. G, are you ready in the matter?
My lords, this is for admission. My lords, in fact, there was suppression of facts for which the impugned order has been passed. My lords, the respondent was appointed as helper.
It was about pensionary benefit.
My lords, but his regularization prayer was rejected by the learned tribunal. That was challenged before the High Court, and that is pending. That fact was not before the.
How many years of service he has put in?
My lords, from 94 it is adequate.
94?
Appointed on 1587.
87.
1587.
87, 97, 2007, 2017.
No, lords, in order it is written 87, but as per my brief, it is 4/2/2094. He was appointed, and his appointment was cancelled.
No. He was regularized on 24/1/1994.
15/5/1997. Next.
That is reflected in the order of the Honorable Single Judge. But so far.
No, my brother is right. He was regularized on 24/1/1994.
My lord,
resolution dated
my lords, after that, that order was recalled by order dated 30 March 2094.
30 March
1994.
1994? Immediately after 2 months.
My lord. That was challenged in OA number 1378 of 1994.
What happened to that?
That was rejected.
That is challenged in WP. That WP is pending.
Pending.
Even now.
Not.
Retired since 2022.
22. But this order has not taken note of that writ petition. If that is against them also, it will be.
So that was your plea with the.
My lords, it was first instance, it was.
Issue emergent notice.
That is delay, my lord.
Therefore, let notice go.
My lord.
But assuming that, of course, as you rightly said. Yes.
Item 57, Rate Appeal 1580/2025.
Dismissed.
In this case, I am appealing for respondent, state appeal, my lord.
What is this matter?
My lords, here, this is
In this case also, there is a delay of 100 some days.
126.
126. Copy of the writ appeal and limitation petition may be served on me.
Okay, man. I'll serve by tomorrow.
We will allow that application subject to payment.
Yes.
This intra-court appeal is filed looking a short delay of 122 days.
26.
26? 122 days. First of all, the application in IA number 4495 of, sorry. Supported by an affidavit accompanies the appeal memo. First off, some explanation has been offered for the delay fluke. First off, however, we are not fully satisfied with that. First off, in similar matters, we have condoned delay after levying a cost of ₹20 per day of delay. And therefore, in this case also, we propose to do the same. Next paragraph. In the above circumstances, application having been favored, the delay of 126 days has been condoned, subject to the appellant paying rupees, how much it will be?
2,520
means
2,520.
2,520 to the respondent, only one person, respondent employee within 3 weeks, failing which the application shall be deemed to have been rejected.
They are not employees.
Not employee, remove that word employee. Deemed to have been rejected, and as a consequence, the appeal to first call up to 3 weeks.
Item 58, Rate Appeal 1593 of 2025.
In this case, my lord, same party, same cause of action. Your lordship has disposed of one writ appeal. Same, it would be res judicata if the
the same relief has been granted.
Same relief
Why
was
another
granted.
appeal?
In this case, in this writ appeal, I have filed against that order. Director has rejected the writ petition order. So against that order, I filed a writ petition. That was also upheld by this court. Against that order, he is filed the appeal.
So it is covered by this judgment.
Yes. This is the same party, same cause, same for regularization of the post.
Only
Nothing is
but nothing remains in this case, writ appeal.
It was
already,
yes,
it is decided.
Yes.
my lord's appeal by me.
Your appeal. Earlier also your appeal only.
These are two writ appeal.
Okay.
They are filed.
Then we will dispose of
That order is
Just
not
look.
with.
Then just see.
Taking.
You take print out.
Earlier, I said this is for regularization.
How many years of service he has done?
He has been service from 2000. Yeah.
But court has taken into consideration 2012.
Shripad and others we have followed. In this,
He was in service from since
No, this was on the ground of delay we have done that.
Yes,
But in this case, how many days of delay?
144 days.
Then that was a case of 4 years.
Yes, thereafter, after 4 years, they have filed this writ appeal, this writ appeal.
This is 144 days delay.
No,
It is 144.
16/10/2000. You are appointed on which date?
My lord,
You are appointed?
after in this case, in this writ petition, I have appeared.
That's all right. When were you appointed for the first time?
First time in the 2024.
24.
Yes, that
No, you are appointed. My lord's, his case is that he first appointed in 2000. But
My lord,
later
sorry.
in 2012, he was given.
I think myself, the party is appointed in 2000. Since 2012, he was treated as a contractual employee. Thereafter, in the 2021, he filed for regularization. That was rejected by the director. Against that order, I filed this 2024 writ petition. That was also upheld by the previous writ order. Against that order,
Brother, Bevla, it is covered by the second paragraph of our judgment. In second paragraph,
in
the
fact,
connected
my lord,
matter, identical. But 16/10/2000 appointment and 2012 on contract, 2002 contract basis.
For 12 years he was in.
He was 12 years he has been in service. Even now he is continuing.
Yes, he is still continuing.
Then right off. The state is in intra-court appeal for laying a challenge to a learned single judge's order dated 4/4/2025, whereby respondent employees WPC number 19.69 of 2024 having been favored.
My lords, now, in the earlier WPC, there was an order, and that was challenged. That was dismissed.
That was rejected by
So that order becomes final.
No.
The subsequent one.
Subsequent, because it's a regulation matter. For that, the res judicata will not come in.
No, I am not telling res judicata.
Right off. Whereby WPC number so having been favored, a direction has been given to the appellant's area.
My lords, para 3 of the impugned order, what I was pointing out, petition, he further contended that finally, by order dated 29/9/2012, the petitioner was appointed as
contract.
Lordship may confirm this.
That's what. That's what. Reproduce para 14. Go to para 15. Para as that para 15. First. Next paragraph. Learned single judge, while granting relief as above, has observed that paragraph
3, my lords.
Para 3 as under. Yes. Next paragraph. One line. We agree with the above of judge. Next paragraph. Yet another reason as to we do not propose to incline, we are not inclined to grant indulgence in the matter is that in almost identical matter, namely writ appeal number 1601 of 2025.
My lords, I think that is the same person.
Same party.
Same party.
Because the honored single judge has stated that earlier there was a direction for regularization You have traveled beyond that and you have reconsidered and rejected. You do not. That order was
Other ground may not be necessary at all. Let the same party, Maheshwar.
Yes.
Party.
I have verified.
In the above circumstance, his appeal also has to meet the same fate, namely dismissal. First off, impugned order of the learned single judge has to be given effect to in letter and spirit within an outer limit of 3 months. Failing which the contempt action may follow. What's made easy?
Item 59. Rate appeal 1653 of 2025.
Yes, Mr. Farangi.
Here, Sumoto, your lordship, since there is delay also, 184 days or so.
184.
Yes.
Let them pay some money to you.
Let him serve a copy on me.
No. This intra-court appeal that placed a challenge to the this intra-court appeal calling in question a learned single judge's order is filed after booking a long delay of 184 days. First up, an application in I number 4131 of 2025 supported by an affidavit accompanies the appeal. First, some explanation has been offered for the long delay proved. First, however, they are not fully satisfied with such explanation. First, in matters this, we have condoned delay being a cost of ₹20 per day, and therefore we propose to follow the same in this matter as well. First, in the above circumstances, application having been favored, delay is condoned, subject to appellants collectively paying a sum of rupees. How much it will be? Calculations.
3648.
3648.
36
within
08.
limit of 3 weeks.
608.
Failing which the application shall be deemed to be rejected, and as a consequence, appeal also.
That is the
First stop. All up to 3 weeks. Yes. Next.
Item 60. Rate appeal 1784 of 2025.
None appears for the appellant. All up to 4 weeks.
Item 61. Rate appeal 1846 of 2025.
Brother Behra,
Milo.
in that 14 days delay, 60, will condone a short delay. Issue notice. Learned AGA, Mr. Behra is requested to accept notice for the official respondents. Accountant General is by whom? Mr. Learned Panel Counsel Sri A.S. Patra is requested to accept notice for response number 3. First up, appeal is filed after booking a short delay of 14 days and an application submitted by affidavit in I number 4497 of 2025 is also filed seeking its condonation. It is supported by an affidavit. First, delay is very short and no prejudice will be caused to the other side if the same is condoned. First, the plausible explanation is also offered for the delay proved. First, in the above circumstances, application having been favored, delay is condoned. Yes, next.
Item 61. Rate appeal 1846 of 2025.
Where delay is condoned, what for admission? Okay, that all.
Item 61.
61, 7 days delay.
61, 7 days.
You are respondent, na?
6 days delay.
Sorry, 61.
Yes.
61 is
6 days delay.
See, the year number is different. Just to keep. All right. 6 days. 6 days. 6 days delay.
6 days.
6 days delay. Take on. Mr. Mohanty requested to accept notice. All respondents, you only.
Yes.
All right.
No, accountant general.
Accountant.
Accountant Mr. Patra will OP number
This one all government. All government.
Previous is 14 days to the
That's all government.
61. Mr. Patra.
That's Patra Pro.
OP number 3. Delay control. 6 days delay. Same order. Yes. Next.
Item 62,
Good for it.
Rate Appeal 1850/2025.
In this case, I am appearing for the responding number 3 and 4. Associate is there in court. There is a delay condonation petition, but the date has not been given. But it seems that the order dated 10/10/25, an interim order in a pending writ application, was filed on 16/11/2025.
So 7 days delay. Will condone delay. Delay will condone post for admission. Same. 7 days condone. Post for admission. What do you call it? The admission or preliminary hearing?
Not for admission.
Yes, sir.
After 3 weeks.
Item 63, Rate Appeal 1851/2025.
63 here, my lord, 41 days delay. That's state appeal.
Take notice. Notice has to go, na? Other side. Correct. But unilaterally, how can we deal? If you are responsible, we can deny. We can condone. But if you are appellant, notice has to go. Any your special rules are there which for condonation of the short delay without notice? No.
Is my lord's prerogative.
No, we cannot do that. The 63 issue emergent notice, both on main matter and IA.
Yes, 62 disposed of, no? So for the delay.
62 delay condone.
Because the state is the respondent. He took notice. No? But here state is the appellant. Right. Yes. Next.
Item 64, Rate Appeal 1852/2025.
So I filed a reply to the...
My lord, 122 days.
Nothing survives in the matter, my lords.
Why?
In the contempt application, the contempt what has gone and appeared before filing this writ appeal and given an undertaking to the lower court to the single bench that I will comply to the order in letter and spirit. Given an undertaking, my lords may see. I put
but correct. He will comply with the threat. Otherwise, we will arrest them.
Not threat. There is no threat. What court?
What is that? Contempt is for hugging.
No. Let's say what threat? There is no threat to say and lie when you have already tried to file a writ appeal.
No, that's not it.
Now that
we threaten them here, and if they comply with that, if you say they don't have right of appeal, where they should go?
By the right of appeal has been initiated by asking the senior officers that we want to go for appeal. So he had the intention that I have the right to file an appeal, but he has given a complaint.
Iyer, so beautifully and broadly. Both Braley, both they have discussed this aspect of the matter.
Now, other than that, Millards, my money, they sit over for a longer period. Interest is the only thing that has been allowed to me, nothing more. There is no.
Millard, apart from the delay, may I say, this is a contract between the parties X and Y, state along with the others. Fact remains, so far the admitted amount is concerned, this has been disbursed. Absolutely, there is no problem. So far, the
but 2.79 crore.
Exactly. Labor component and interest there too. The present respondent and the petition and the application, he is somebody else with different entity who has filed this.
He is not concerned.
No. That is the crux of it.
Who is that person?
My learned friend is...
Not what is it? To say, substantiate this contention. Minimum argument you have to do. Take us to the papers.
One, Honda Infratech.
Honda Infratech is the entity with which you entered into contract.
Yes, exactly.
Who is he? This person. Whether Infotech was a partnership firm or a company?
Company.
Cooperative. And the person now, who are you?
I am the same Honda Infratech. In the meanwhile, I have changed my name to Pratishtha Engineering. Well, CIN remains constant. The company identification number remains constant.
No, whether you changed only name?
Only name.
Where is that document?
Document.
ROC, you have taken permission of that?
Yes. Millards may see page 19, page 18 of my reply.
certificate of incorporation pursuant to change of name.
Yes.
Pursuant to 29th Company Incorporation Rules 2014. You find that the name of the company has been changed from Panda Infotech Limited. Effect from only name is changed.
Name is changed. And the
Company remains as it is. Change of name.
And earlier occasion, the amount so due, this has been duly accepted by the Panda.
Correct.
Without any. This is an interest on the delayed payment.
Correct.
They are saying. So the payment has been made in due time.
Now, to show that when you should have made the payment.
But agreement was entered in.
No, when you ought to have made the payment. Otherwise, interest.
Yes.
So is that Interest Act 1984 Act?
Section 88 minutes.
Section 88 Act.
Understood.
Where state retains money.
1978 minutes.
78 Act.
Yes.
You are right. Section 3.
Yes.
Give that section.
Commercial
Vote to allow interest in any proceeding for the require of any debt or damage, any proceeding which interest from any debt or damage already paid to the court in existing fee. Allow interest to the person entitled to the debt or damages or to the person making such claim as the case may be at a rate not exceeding the current rate of interest for the whole or part of following period.
I have been paid less than the current rate of interest.
You have been paid less than that.
Director Honorable Single Judge has added, has given me interest.
At the rate of 9% he has given.
Yes.
What is the current rate of?
12.5 in loan account.
No.
Loan 9.
No.
You are saying savings here?
Huh?
Savings 7.5. Highest rate of savings.
Highest is
senior citizen.
7.49.
Yes, 7.49, 7.5. 7.49. By that.
7.49.
Yes.
And you have been allowed 9%.
9%. 1.5% difference.
If you allow, then we will tell them. Why 9%? Government money. Why government should pay more than what you would have got had you put the money in a basket of the bank?
Because I'm a businessman. I wouldn't have put the money in the basket of the bank. I would have invested somewhere. My answer to that, with all due respect.
No, that's all right. But you said that. But section 3 says current rate of interest.
Yes.
It does not say commercial interest.
That interest act is also subject to other conditions of the contract, my lord.
No, which condition?
That you have to.
No, that you have to put forth.
There is no such interest barring clause. I have checked. We have also, that was also put forth and we have argued on that.
No, section
4.
No, 2.
2. Definition of current rate of interest.
The current rate of interest.
Yes. Now, court is also defined 2. This is not applicable.
Then on what basis will the correct?
Yes.
Courts have taken the 3 high courts have taken.
Yes, high courts have taken this. Yes, I know.
It cannot be more than 7.49%.
I can give in 5 minutes of Passover. I'll just take a consent from my client that he's agreeing, and if he agrees and immediately convey, then we can.
We'll also take the instructions.
We'll call this next week.
Next week.
Call next week. There is one Justice Dalvir Bhandari's judgment on commercial. No, commercial transactions. What should be the rate of interest? Just look into that.
Yes. The rate of interest also is not a dispute, but in the state of appeal memorandum has not been raised.
But section itself says, just look into.
I will just, I also find out on this issue. Let's call it on Tuesday. Tuesday as it will come up as a fresh.
No, this week were completely loaded.
Next week, Tuesday.
Tuesday.
21st, my lord.
21st.
Sorry, I'm sorry. 24th, my lord.
24.
Much appreciated.
Yes, next.
Item six.
Delay be condoned, may.
We will condone the delay.
122 days.
122 days delay. 22 days. Same that way. Okay.
Item 65, Writ Appeal 189 for 2025.
87 days delay.
Emergent notice. Both on main matter and IUP. Yes.
Item 66, Writ Appeal 1930 of 2025.
None appeals, call up to proceedings. None appeals for the appellant. Call up to proceedings.
Item 67, Writ Appeal 1946 of 2025.
I am the respondent, man.
My lords, I'm appearing for the appellant. In the last occasion, my lords had asked to file the condonation of delay application.
How many days delay?
484.
484 days of it.
484.
Yes, my lords.
What is the explanation?
My lords, with the appellants had filed a review petition before the learned single judge, where the
Impugned order is dated
16/7/24, man.
16/7/24, and the review petition was dismissed on 21/11/20.
whether review petition was filed in time.
No,
370 days delay.
Then
my lords, my lords, the delay was because of multiple writ petitions that had been previously filed by the respondent, and then again the appellants had to take time for took time to obtain multiple documents that were not furnished during the course of those litigations. And my lords had asked to present the decision of State of Karnataka versus Nagappa, wherein the condonation of delay application was filed after the
filing of appeal.
Yes.
Justice Venkatachala judgment. Rajashekara Murthy.
Yes, Venkatachala and Hapri.
Since at the time of filing of the writ of appeal, my lord.
It was delayed also. Only 8 days. How many days? No,
370 days delay during the review.
Report is 8 days.
No, my lord. What happens?
This is your writ appeal 1946.
Yes, ma'am.
It is.
No, my lord. What happens, my lord, in this case? They have filed the review in the writ petition.
Whatever the office report shows, only 8.
No, the petition filed by the appellant, my lord, stating therein that 484 days delay, man. Because the order dated 16/7/2024 was in challenge in the year 2025, man.
No, but the review also intervened.
Yes, my lords.
There was a review petition.
Yes,
man. The review petition has been rejected only on the ground of delay of 370 days.
On the ground of delay?
Yes, man. It was rejected on the ground of delay. Then
you pay cost of 25 rupees per day. You are a municipal corporation. Yeah. Shall we make that order? Or you want to withdraw the appeal? Otherwise, we will say on both on delay and merits dismissed. What is that order? Disperse the dues.
Sorry, my lord.
The direction is for dispersal of the dues.
Yes, ma'am.
I will be. The respondent, when the benefit of RACP was not allowed in favor of the respondent, he approached this Honorable Court in a single bench. This Honorable Court directed the government to take a decision. The government under Annexure 14 has taken a decision and directed the municipality, Cuttack Municipal Corporation, to release the pay as well as sanction the RACP. Well, that was not been. Yes, my lord.
Lords, the RACP was released by BMC previously. The first RACP was released by BMC, which was wrongly done so under annexure, my lords. Just give me a minute.
No, you have released the amount pursuant to direction of the government.
For which, my lord, I may be 1 minute time. the government has directed the Cuttack municipality to pay the sanction the RSCP and all benefits to the respondent.
Where is
when
that?
Annex 14, my lord, of the appeal, page number 68.
12/2/2024.
Yes, my lord. No, my lord. 22/3/24.
22/3/24. Annex 4.
Annex 14.
Yes, this is true.
So far they have supplied the copy of writ appeal to me, my lord. Last paragraph, page 68. And when the authority, municipal authority has not paid the same, they present
For RSCP, whether the government has got power to give direction to the corporation.
Yes, my lord, because the RSCP was previously allowed in favor of the petition respondent, my lord. When he was continuing at Bhubaneswar Municipal Corporation, when he was transferred to Cuttack Municipal Corporation, the same have been raised objection and
Government itself has directed you to make the payment.
And the
Can you
present-
sit in appeal over the government decision?
for which this is not maintainable. Because when they have not complied with, I again approach this Honorable Court in the present writ petition. And the Honorable Court has only, your Lordship may present impugned order, only directed to comply with the government order within a stipulated period. That has been challenged.
No, brother, you don't have a case. You can't sit in appeal over your master.
Yes, ma'am.
You cannot
That
be
is my case,
more
ma'am.
loyal than the king himself. This intra-court appeal by the municipal corporation seeks to lay a challenge to the two learned single judges order dated. Go to order
16/7/24.
16/7/2024.
My lord,
Page 25.
16/7/2024, whereby respondents WPC number 168
my lord,
2024 having
this might
favored.
be adjourned to 16th.
Why?
I would take instructions from my senior.
Your senior is appearing in this matter.
Yes, my lords.
I'll let him come.
I have
I'll call this matter on 23. On 23.
When the contempt proceeding is going on and direction for appearance was there for the municipal commissioner is concerned, they filed the writ appeal.
We are giving time because he's
Yes, I have not objected to that submission, ma'am.
Anyway, there are judgments. Is there any provision in the Corporation Act which says government can give direction to municipal corporations?
I will try to.
Just look into.
Yes.
My lords, there is a contempt petition on the filed by the respondents.
Till next date, you don't precipitate.
Yes, I am not pressing also since the last 2 months.
After call this matter on 23/3/2026, and in the meanwhile,
no order is required, my lord. I am not pressing since last.
learned judge may not.
No, my lord, I am not pressing at all there. Since the WA is pending, I am pressing there at all.
Cabinet counsel for the appellant submits that a contempt proceeding is pending as a hanging sword on the head of his officials, and therefore there should be interdiction of the same. First, learned counsel appearing for the respondent in appreciable fairness submits that he will not precipitate the contempt proceeding till next date of hearing. All.
Item 68, writ appeal 2034 of 2025.
There is a delay of 125 days in filing of this appeal, my lord.
Yeah. What is the explanation?
Explanation, my lord. There was some puja vacation and he
Puja vacation for 124?
No,
You checked it.
then he was in delay. First he came to the lawyer, thereafter he had some discussion, thereafter he filed the case. That is what I have explained in para 3.
What is his qualification?
He is a company secretary, my lord.
Then we will not condone. He is a company secretary.
No.
A company secretary means he has to do that
Everything diligently.
IFWAI.
Only
IFWAI he is not even CA. It is more than CA. IFWAI is considered to be very, very lucrative practice. Therefore, for him, some farmer, some employee, saying all that we can understand. Some SCBC, we can understand. Not company secretary. No, let us read your application. We will not that mindlessly condone the delay. Read your application.
Condonation of delay, my lord.
What the explanation you offer?
The judge has been pleased to dismiss the writ by judgment dated 28/7/2025.
Therefore, the writ was supposed to be filed on or before 27/9/25, but it is submitted after being intimated by the dismissal of the writ application. The petitioner discussed with his lawyer and could not decide immediately whether he would prefer the writ appeal. In the meantime, the court remained closed for puja vacation. Thereafter, the petitioner was taken ill for some days.
Puja vacation from which date to which date? Court's vacation. Egypt holiday or vacation?
Holidays.
Holiday. Then read which is that when vacation holiday was there, when court reopened, when he woke up from his deep slumber, all these things have to be stated. You are not some downtrodden people or agriculturist, laborer, pagan, not like that. The employee of group C, D, then we will condone the delay. But not for WAI candidate. No. He consulted his friends. No, he consulted everybody, then he...
Lawyers, friends, relatives, everyone.
Acquaintance. No answer. Which lawyer was consulted?
Let me find a better affidavit.
No, you will better everything by for subsequent affidavits, but that will not help. Which lawyer was consulted? And what he said him? You have to say the name of the person, na? Puja vacation. That is a very too vague. Who told you not to puja? We also do a puja every day. That is no answer. No, we are not. We are dismissing the.
No, I was in this merits. I was dismissed, my lord. I was terminated without any so cause or on merits, my lord, without following natural justice.
But your version of your client appears to be doubtful. It's a case of falsus in uni, falsus omnibus. If you lie once, then everything is taken to be lie only. So casual. You pay 25,000 rupees a library. You'll condone delay. How long he has been in practice?
In this post, my lord. This post he was under probation for 4 months only.
4 months.
4 months. And he was terminated without any so cause, without any That is my ground of challenge, my lord.
All right, you pay books worth rupees 5,000 to the library. Then we look into. Okay? Who appears for the OP?
No, notice has to go. Police Housing Corporation.
Issue notice on both main matter and the application. If petitioner credits, appellant credits a sum of rupees 5,000 to the advocate's library for buying books within one week, failing which the application for condonation of delay shall be treated as having been dismissed, rejected, and therefore appeal as well.
I will pay only the money, or I will
deposit money. They will buy
in the library.
Yes, library. Okay.
Item 69, Writ Appeal 327 of 2024.
69, this is the...
We'll come back. We'll come back.
I beg your pardon, my lords. Item number 52, my lords, my learned senior, the panel counsel, he could not appear before, my lords, because he was engaged in another court.
52,
my lords. The matter has been posted to 3 weeks after.
We have posted it after 3 weeks because there was none.
My lords, I deeply apologize, my lords. There is a contempt application pending. So what I'm praying is, my lords, next week or the week that.
Week after next, all right. Week after next. Also. Next.